Are you having a family dispute? Go to judyjustice.tv.
Case 2140, DeTorres versus Young.
Thank you.
You're welcome.
Mr. DeTorres, according to your complaint, you did some work for the defendant as a plumber, didn't work out, and he terminated you, and he owes you some wages.
Yes, ma'am.
The defendant says that while your work in the beginning was okay, you were never an employee of his, you're an independent contractor. That's the way he sets it up, and he's going to explain that to me. That he paid you your wages even though the last job that you did cost him an awful lot to repair. He was not happy with the quality of work that you did, and his counterclaim is for vandalism, something that happened with his truck, work hours lost due to your incompetence. That I'm not going to hear, sir. You know, you make a choice with an employee, and if it turns out to be something that is less than satisfactory, then you let them go. But the one who I assume suffered from what you call lack of quality work that he performed was the person that you were working for. Was that a private residence that he was doing work in?
Yes. Yeah, a bunch of private residents.
Yeah, that's the person who suffered.
Yes.
Yeah, sure. Okay, so we're going to make this as easy as possible. From what days to what days did you work?
I worked for Chad from June 13th to August 3rd.
And how much were you supposed to be paid?
For those 3 days, $840.
And that's for 3 days' work?
Yes, ma'am.
Did you say June 13th?
Yes, ma'am.
To August 3rd?
Correct.
Well, that's more than 3 days.
No, his wage he owes me from August 1st to August 3rd is what he did not pay me for.
Okay, and where did you work during those days?
Multiple residents.
Okay, do you have any sort of a call log from him?
I do. It's right here in my
Do you dispute that he worked from August 1st, 2nd, and 3rd?
Yes.
You dispute that
There was one day he actually did one of my jobs for a couple hours that day.
Doesn't matter. He has a log.
Half a day for one day.
Did you pay him for that half day?
I did not, because the job was done incorrectly multiple times.
But he did that job. Okay, now, do you have a log?
As in?
It's some sort of a work log. You have a business. You have people who are general contractors. You get a call. You don't have a payroll because you pay these people independently. Do you pay them in cash or check?
Both.
Well, how did you pay him?
Sometimes it was through a cashier's check and sometimes it was cash.
Okay, but never through a company check where you deducted Social Security.
No, because I 1099 all my employees, so they're all self-employed, so they have to do all that on their own.
I do understand. I mean, you're not the inventor of this whole system, sir, of paying in cash. Okay. Are you one of those independent contractors?
Yes, ma'am.
Stand up. How long have you been an independent contractor?
I've been contracted with Chad since July 5th.
Of what year?
This year, 2022.
Oh, so short term.
Yes, ma'am.
Does he pay you in check or cash? No, look at me.
Check it first, and then later on it became through Venmo, and then it's gone back to check now.
What kind of check?
Cashier's check.
Just a straight cashier's check with nothing taken out?
No, ma'am.
No, I go to my bank to get all that.
What?
I go to my bank to get the cashier's checks, and sometimes I Venmo him the payment too, just to pay.
I understand, but sir, you're not the first person who I know who pays their people in cash and says that you're independent contractors. You're independent contractors. I don't want to know about it. What name do you use for the cashier's checks?
My personal name.
Is this the first time you've worked for him?
Yes.
Okay, let me see what you have for August 1st, 2nd, and 3rd. Where did you work? Come on.
There were multiple residents, ma'am.
Well, you have to tell me so that he can answer. He said that you worked half a day that he didn't pay you for.
Yes, ma'am.
So let's say that's a full day. So that's $200.
Okay. See, he would email it on his work phone, and I'd follow the addresses there.
Well, then you would have it on your phone.
My short notes on this.
Just a second. Then you would have it on your phone.
It was his company phone. He took it back when he came to my house unannounced and told me that I was fired. Redeemed his truck. Got my tools out of his vehicle.
Okay, just a second. Do you have your phone?
I do. I have my personal one that I.
What about the phone that you took from him?
No, that one's actually broke, so it's been with Mo for the past week.
Let me see the notes that you have that you took.
Yes, ma'am.
Fascinating.
It's my shorthand, ma'am.
How do I know what dates these are for?
It was all on his phone. ma'am.
Well, that's not him to have to prove, sir.
I wasn't able to prove anything when he took his phone back. I just had that's the notes when I was employed for him as I wrote down.
It's not helpful to me.
Yes, ma'am.
So far, the only thing that he's acknowledged is that he owes you a day's wages.
Yes, ma'am.
Just $210. The other part of your complaint is a false restraining order against you.
Yes, ma'am.
Did you file a restraining order against him? Do you have a copy of what you wrote in your restraining order?
I do.
I'd like to see it.
So what got me that restraining order is he called and made threats and made
Was
threats.
this after you fired him?
It was.
Okay, so after you fired him, he called you.
Made threats.
Well, what did he say when he called you?
Just basically talking about I'm going to come to your house and everything.
He wanted money.
I guess, yeah.
He said, you didn't pay me.
Yeah.
Okay. You say you got a text message and voicemail from Jeremy threatening to come to my place of residence.
Yes.
Can I hear it?
Yeah. Do you want me to play it? Or do you want to look at it?
I want to look at it.
Okay.
So, Mr. Torres, did you, after he fired you and came to your residence, took your house, did you call him threatening to come to his house?
I did.
You did?
With the police. It says it on these text messages, ma'am.
Okay. I'm going to take his phone and those text messages.
There's more text. That's just the one where he said he'd send me my money.
That's the voicemail, if you want me to play it for you. Sometimes the transcription doesn't work.
Yeah.
You want me to play it?
Just.
Hey, bro. I definitely worked more than 9 hours for the last week that I worked for you. I'll be contacting my... Play with me. I'll show up at your house.
Yeah, that's a threat.
With the police.
Just a second. That's a threat.
Yes, ma'am.
Okay.
I've had more.
That's a threat.
I
Just
had
a
more incidents before that as well.
May I say something, ma'am? He accused me of going into his gated community, slashing tires on his work vehicle. I stated that I was going to come to his house after, if you read my text, I said to him, hey, bro, I think I misunderstood your text message. If I did, my bad. If not, I'll show up at your house with the police. I never went to his house. I waited to see if he'd be the big man and just send me my money like he said he would.
I listened to the message, sir.
Yes, ma'am.
The message sounded threatening.
Did you read the rest of them?
I don't care. That message sounded threatening. Where does it say here that his tires were slashed?
In my mind, somebody writing that against me, flattened tires, what else would it be?
But you have to understand that that's not what this says.
And later today,
I was financially struggling.
Well, you weren't living together at the time.
No, she would periodically come over and
yeah, but
stay at
you
my
weren't living together at the time. So how would she find out that you were in financial trouble?
Jeremy DeTorres claims his former employer, Chad Young, owes for unpaid wages and filing a false restraining order.
Okay, that message alone, if he felt threatened because you were going to come to his house, and you not only said you were going to come to his house, but you used an expletive before you did that, which sounded threatening. This may be more benign, but that phone message was sufficient for him to file for a protective order against you.
Okay, why didn't he show up at the protective custody order?
I don't answer your questions.
No,
you don't necessarily.
Absolutely.
Some people don't pursue it because once it's done, it's done.
It wasn't done.
And once it's
This
done,
is the dismissal right here. Dismissal for the
No,
injunction.
it didn't show up. I understand he didn't show up, sir.
Yes, ma'am.
But I'm saying to you, I listened to your text message,
ma'am.
and he had an absolute right to see.
Can you see where he threatened me as well with all these back and forth texts and calling each other? Because it's in the text
You're
messages.
suing him for money owed for wages and filing a false restraining order.
Okay.
You've proven that you worked an additional day for which he didn't pay you, which is $210. He has a counterclaim. Yeah. He says that you vandalized the tires on his car. The rest of it, I'm not dealing with, sir. You picked this employee. You don't then sue the employee if you don't like the job that they do. You fire them and you get somebody else to do the job. But you can't sue him because did the person who you did the job for sue you?
No, because I've got a really good reputation with my customers.
Because you fixed it. Because it wasn't done right.
Yeah.
Okay.
Even up to that last day I said he worked for me, that job I had to go back to 2 weeks ago that they couldn't close on the house.
And next time you won't hire him. Yeah. Maybe other people won't either. But I want you to tell me about the tires. I want you to tell me what proof do you have that he had anything to do with your tires? When were the tires slashed, flattened?
So the police report was done Friday when he made the threats.
Friday, what's the date?
I got the date right here. I think it was
August 5th.
Yeah, so August 5th is when he did it.
August 5th is when?
The police report was made for the threats.
For the threat, for the voicemail?
Yes.
Okay.
Okay, so it was the end of the day Friday, so court's closed for the weekend.
August 5th?
Yep. And then Monday, the 8th, I went outside to go to work. My tires were slashed in the end. At that point, I realized it was just over and done, and I need to go down and get a restraining order so people can't come onto my, my property.
Because
area.
you believed it was the plaintiff who was responsible. You believed you didn't have proof at the time.
Yes.
You didn't have proof.
Again, and even in my injunction, I knew all I needed was this police report to get the injunction, so I just put in my police report.
You're not talking about an injunction. You're talking about a restraining order.
Yeah, the restraining order. Yeah.
Okay.
I went to file the restraining. So in my restraining order, I put just my tires were flat. I did not put my tires were slashed at any point because I knew the police report was enough to get the restraining order.
Okay, your
so I
tires
didn't
were
go in
flat.
detail about my tires.
Okay, so in the police report, you have that your tires were flattened.
No, that wasn't on the police report because that didn't happen yet. The tire incident did not happen.
Okay.
That happened Friday. Monday morning, I went out in my vehicle to go to work. That's when I found them flat and slashed.
Did you file another police report?
That's when I went and filed the restraining order that day. And
Okay, and in the application for a restraining order, you said?
That my tires were flat, and that was it.
Yes, okay.
I didn't mention that they were slashed.
Correct.
So I don't know how he would know my tires were slashed if I didn't mention it on my restraining order.
I don't know. That's an interesting question. Mr. DeTorres. Mr. DeTorres, stop your paper fluttering.
Okay.
What made you think that the defendant's tires were slashed rather than just the air let out of them?
Because I read this police report and it has a mark right here saying, or the file that he did.
Show me. And make a circle.
Right here, damaged property is what I read. He checked that I damaged his property because this is written against me.
Mr. DeTorres, do you understand my question, sir?
Yes, ma'am. I'm sorry. I'm nervous in the
Just a second. This has nothing to do with nerves, Mr. DeTorres.
Well, I had no sleep last night.
That has nothing to do with sleep.
As far as not being...
Just a second.
Yes, ma'am.
What I'm asking you, Mr. DeTorres, is where does it say here that his tires were slashed?
In my mind, somebody writing that against me, flattened tires, what else would it be? He lives in a gated community.
Well, that could be...
Where's the surveillance showing me that my leg injury, the way I walk, is very distinctive, okay? If he's got proof that I slashed or flattened his tires, I said slashed. It's the same thing as flattened in my mind. That's the way I think. The way I read that, that's just how it came out of my mouth.
But you have to understand that that's not what this says.
Okay. It says that I damaged his property.
He said damaged his property, and you said slashed tires.
Okay.
Okay?
Yes, ma'am.
How much were the tires?
$450.
Let me see the receipt.
I do not have a receipt because I pay cash for my tires.
Well, that's too bad. You better stop paying cash, sir. You can pay cash for tires.
Yeah.
But when you buy tires with cash and you want to sue for them, you get a receipt.
Yeah.
From the people. And if you know you're coming to court, we're not talking about things that happened 2 years ago.
Yeah.
You were coming to court today.
I went back to the tire shop and he's like, we always do cash for all your vehicles. And
well, what do you mean cash for all your vehicles? That means you get a receipt. All right, your counterclaim's dismissed because you have no proof of anything. On the complaint, sir, I'm awarding you $210, which is 1 day's pay. Thank you very much. This case is over.
This court is adjourned.
The work just wasn't up to the quality that he promised he was going to offer.
It is what it is.
That's just his nature. That's always been his nature.
The judgment is what the judgment is. She felt like I was only awarded a day's pay, and that's what she gave me.
Keep doing what I do. That's all I can do every day.
Well, Sarah Rose, that is the perfect example of you're supposed to have proof when you come to court.
Yep. Standard of proof exists for a reason.
You know, I know that when I go someplace, and sometimes I pay cash. So even if you pay cash for something,
There's some
or Venmo,
record. Venmo
you're
keeps a good
supposed to
record.
get a receipt in the event that you want to use whatever you bought and use that fact that you purchased something in a subsequent lawsuit.
Yeah.
It's the same thing as sending a gift. If you send somebody a gift, you keep the receipt until you know that they got the gift. Then you take it and you throw it away. It's just
good bookkeeping. It's good record keeping.
And he's a business guy.
Yeah,
he's a business guy. Didn't make sense to me, but clearly plaintiff is somebody who has a little trouble.
Yeah.
Case 2067, Garcia versus Taryn. All parties, please step forward.
Amari Garcia is suing fellow motorist April Taryn for damages from a motorcycle accident.
This is a case that's about an automobile motorcycle collision. Each one of you claims that the other is responsible for the collision. Miss Garcia, you were riding the motorcycle?
Yes, ma'am.
And you were in your car?
Yes.
Okay. And this happened on what date?
March 21st, 2022, around 3 p.m.
In what state?
California.
In the state of California, are you required to have insurance on a motorcycle?
Yes, Your Honor.
Just liability?
Liability if it's paid for in full, correct. Yes, Your Honor.
And were you insured on that date?
Yes, Your Honor.
And you were driving a car?
Yes.
And was your car insured on March 21st, 2022?
Not at the time.
So the answer is no?
No.
Did you have a valid driver's license on March 21st, 2022?
Yes.
From what state?
California.
What kind of car were you driving?
A 2011 Nissan Sentra.
Was it a new car for you, or did you have it for a while?
It's a new car. I purchased it 3 weeks prior to the incident.
And if you bought it 3 weeks before, how come you didn't have liability insurance?
I was looking for insurance, and plus, at the time, I hadn't received my paperwork. It was still in the other person's name at the used car dealership that I bought it from.
Your Honor.
I hadn't.
You know you're not supposed to be driving a car, Miss Taryn, without insurance.
Yes, I'm aware of that.
Okay. You wanted to say something?
Yes, Your Honor. Thank you. I have proof that April Taryn purchased her vehicle February 8th, 2022. She drove uninsured for 41 days, and it was not from a lot. It was from someone off the street. I have the proof for that.
I'd like to see it.
Yes. Oh, thank you. For $2,050.
Well, this car that you registered, the selling price was $2,050, according to this.
No, it wasn't. And
well, I'm going to show you vehicle and transfer law. This is 2011 Sentra, and it was signed, but it's LLC. That's his company.
Okay.
So it wasn't off the street, but it said the selling price was $2,000. That's what this says.
I don't have my paperwork in my car.
Want to show this to her? I just want to get some basic facts first, and then I'm going to go to the incident.
But that's and
No, the person, the seller.
And you know, I have my paperwork in my car.
Well, but you understand that that's
I understand
what,
what you said because it's right there.
That's
yes.
Okay, we have a diagram. This happened on March 21st, 3 o'clock in the afternoon. You had no insurance, and you were traveling in the bike lane.
No, that is not true. I shared the lane of the car on the right. I would never go into a bike lane. That is disrespectful to the road and riders.
Just a second. Are you allowed to share a lane with a car and a motorcycle?
That is your right, yes.
I know Foothill. Is that where you were?
Yes, Your Honor.
And at a certain time during the day, Foothill becomes very trafficked.
Yes.
And the cars sometimes get stopped because there's a light, right?
Yes, Your Honor.
Go over to there, Miss Garcia, and show me, please, where you were positioned before you say that you were traveling in the same lane as a car.
Your Honor, I was directly behind this car.
Okay.
Directly behind.
You were directly behind that car.
Yes.
And that car was stopped.
They were slowing to a stop.
No, they were stopped because they had to have been stopped because that's why you went around him.
They were slowing to a stop. By the time I got around here, they were stopped. I didn't want to veer into here. I was slowing down. I was around 25 miles per hour. This lane at the time was too close. So I shared this lane on this side.
Miss Garcia, I got it, Miss Garcia. You want me to appreciate the fact that you wanted to get around the stopped car and you wanted to continue to go straight, correct? You weren't turning. You wanted to go straight.
I was going straight, correct.
And so you want me to picture in this tiny mind of mine that instead of going into a perfectly clear bike lane, you inched your way at 25 miles an hour in the same lane as a stopped car.
Yes.
But,
this diagram...
You know, I find that hard to believe, Ms. Garcia.
Your
I
Honor,
really find that hard to believe. You may be in the right with regard to this, but I find it hard to believe.
The roads are very wide. I have the actual police photo document of that.
I'd like to see it.
Yes, Your Honor. Right here.
And I'd like to see the police report as well. Is there a police report?
It's attached to this.
Fine. Because as you were traveling straight, the defendant was making a left turn. She was making a left turn because the two cars there were stopped, and those were the only two traffic lanes there. Now, I don't know whether she could see whether it's a motorcycle or a bicycle traveling in the bike lane, but what happened was she was making a left turn. According to this, you went into her passenger side. Is that correct?
Yes, Your Honor.
So where is the motorcycle now?
I no longer have it. The towing company, they sold it.
What are you driving around in now?
1995 Chevy Baville.
Atta girl!
Amari Garcia is accusing fellow motorist April Taryn of damaging her motorcycle. April claims Amari was illegally driving in the bike lane.
Who was in the car with you, Miss Taryn?
My son and his girlfriend.
One of them had an injury.
Yes. My son's girlfriend, she was in the driver's passenger side, and while I was turning into the lane, I just felt a crash and saw glass going into my car, and then she was cut.
Okay, and you had an injury to your knee?
Yes, I have several injuries, and I have photos as well.
You understand, Miss Taryn, that the police interviewed witnesses. The witnesses were in the stopped cars.
Yes.
And at the end of all of their interviewing process, they determined that you were the cause of the collision. That's what it says.
And I don't...
It says that you caused the collision by violating Vehicle and Traffic Law 21-8001, failure to yield when making a left turn. I determined the cause based upon the parties involved and the physical evidence. That's what the police determined. Okay, well, then that's an easy, based upon the police report, because each of you were going to tell two different stories about what happened that day. Police were there, they looked at the physical evidence, they looked at the injuries, they looked at the damage to the roadway, they interviewed independent witnesses, and that was their determination.
I understand, Judge, but the police report had some inconsistencies where, like, she was driving in the bicycle lane, which is against the law. And what I was doing, I was making a left turn, as you know. And these two front cars, which one of them was a witness.
Yes, that car paused to let you make a left turn.
Yes, both lanes. And I was...
No, you said both lanes.
Both lanes paused.
Well, that's what you say.
Yes.
That's what you say. That's not what this says.
See, but they both did. And as I was...
But I'm just telling you.
No, I know.
Yeah,
that's why
I'm just telling you. That's not what this is. That's what you say. There was nothing that prevented those two cars from going.
Exactly.
There wasn't a traffic light. There wasn't a stoplight at that spot.
Yes.
And there was heavy traffic.
Yes.
So it's your responsibility to make sure if you're making a left turn that you have to yield to all oncoming traffic. And so the fact that you didn't see her is really not relevant. And as long as you understand that this police report supports Ms. Garcia's claim that you caused this accident by making a left turn when you shouldn't have been making a left turn, that's what this says. And that, you know, at the end of the day, it's an accident. That's why it's not called an on purpose. It's called an accident. Neither one of you anticipated it. As far as I'm concerned, Ms. Garcia, you're entitled to be compensated, but I'm going to suggest this to you. If I'm driving a motorcycle, which I would never do, just for me, I think it's wacky. I think there are enough crazy people driving around that I like about 2,000 pounds of steel around me, so that if somebody who is not paying attention and there's an accident, I like to be safe. My first car when I was 17, all my friends were getting these cute little cars, you know, that were convertibles, and my father bought me a 15-year-old blue and white Cadillac sedan. It was so embarrassing to drive around in that car. It was a boat. Oh, come on. Everybody else is getting these cute little Corvettes, even if they're used ones. And my father, who loved me a lot, said to me, sweetheart, if you get into the accident, I want you to come out unscathed. And this ensures that you got a shot if you get into an accident. And I feel better. So I'm just telling you, if you're going to drive a motorcycle, don't take shortcuts. I know this place on Foothill, and I know what happened here. You know, you wanted to go, there was no reason why you couldn't. That's why you drive a motorcycle, because you can get into tight places. But you look like an intelligent young woman.
Thank you, Your Honor.
Don't take chances. That was a chance. It could have been a lot worse. What was the damage to your motorcycle?
I have pictures. Would you like to see them, Your Honor?
I would.
I did look it up. Lane splitting motorcycles is legal in California, based on the California Highway Patrol.
Okay, no, I see the pictures. So where is the motorcycle now?
I no longer have it. The towing company, they sold it. They sold it for $70 they claim, and I got hit with collections afterwards. I have the bill for that if you'd like to see that.
How much did you pay for it?
$6,407.
Do you have the bill?
Yes.
I'd like to see it.
For my motorcycle, what I paid for, correct?
Yes, what you paid for it. What are you driving around in now?
A 1995 Chevy Baville.
Atta girl! Atta girl. Okay. I'm giving you the value of the motorcycle.
Thank you, Your Honor.
It's just $6,407. I'm not splitting whose fault this was, actually, but I'm not awarding you any punitive damages for her. She had injuries in her car. You were slightly injured, but both of you seem fine now. I don't think that you were careful enough when you were going straight and around that car that was stopped. But the defendant didn't have insurance, and she was cited by the police for violation of a traffic law. So I'm giving you the cost of your motorcycle.
Thank you, Your Honor.
Judgment for the plaintiff.
This court is adjourned.
So I actually ended up, after the car had made impact with me, the bike went that way, I went up into the air.
It was really frightening.
I hit the ground, I hit on my elbow.
I've never experienced that before.
I was really scared. I thought, like, oh, this is it, my legs are out.
And like I said, I was being cautious, and
thankfully I wasn't.
But it ended up in that kind of situation.
Definitely more safely as far as better gear, and, you know, like she said, don't take a shortcut or anything of that sort.
So I looked up lane splitting, and in California, it's one of the few states that allows it for motorcyclists. It does say inexperienced riders shouldn't attempt it because, like we see, it's very easy to get hit or for someone not to see you if you're splitting between lanes, but it is legal. So she wasn't in the wrong by lane splitting, but I think it was a sticky situation. You're behind a car, someone's turning.
What does it say if you're injured?
It does say on the Highway Patrol website that you're splitting at your own risk. So any injuries that happen are at your own risk.
So they say if you are lane splitting, it's not illegal. Mm-hmm. But if you have injuries as a result of an accident, if you're lane splitting, you're responsible for your own injuries. Thank you.
You're welcome.
Ms. Paramount, you and the defendant had been friends.
Yes.
And according to what I read, there was a falling out, which you will tell me about briefly. Subsequently, and without too much time having passed, you decided to conduct an intervention, a drug intervention, with the defendant.
Yes.
And it is your claim that during that drug intervention, she damaged your television set, and you want her to pay for a new TV. That's what your case is about. The defendant has a cross-complaint. She says she's missing some sort of a speaker. I don't know what that is. And for the emotional distress that she suffered as a result of this intervention. So I have a couple of questions, just preliminarily. How long have you known each other?
Over 20 years.
Friends?
Yes, best friends. Oh. Former best friends.
Former best friend. But there came a time, according to your complaint, that there was a falling out. And when was that?
That was in May of this year.
And what was the falling out about?
It was about our mutual friend and...
This gentleman?
Yes.
What about your mutual friend?
He was in the hospital, and we were all taking care of him. And she felt adamant to tell me that I need to do certain things for him. And I was letting her know that if he needs to tell me he needs my help, he can tell me.
Okay, there were several people looking after him while he was in the hospital, taking turns. Is that right?
Yes.
And she was telling you things that you should be doing for him, and you said to her, if he wants me to do something, let him tell me, you don't direct me.
Correct.
Okay. Tell me the next thing that happened that brings us to court today.
Well, after that, in May, I blocked her. We didn't speak.
Did you go to visit him?
Oh, yes.
Oh, yes. And did you?
Yes.
So you both did. Okay, so you blocked her in May. Then what's the next thing that happened?
Now we're in September, and this was...
And between May and September, you haven't seen her?
Haven't seen her.
Okay.
And now it's September. It's Labor Day weekend, and our friend Brandon wanted to mend our friendship back together. And it kind of did, because we've been friends for so long. We talked and kind of mended.
Okay.
Okay, so I unblocked her. And then on that Sunday, September 4th, she calls me at 7 o'clock in the morning, and I guess she still felt uneasy about, you know, us not talking for so long, that she demanded an apology from me.
She called you early in the morning demanding an apology for what?
For basically just, I was in the wrong of not listening to her about our friend.
Okay, and then what happened?
So I refused to give her an apology. I said, we can move past it, but I'm not apologizing, which she got upset again and hung up the phone on me. And after that, she basically called a family member of mine.
Not basically.
Sorry.
You say that she placed a call to a family member.
Yes.
Okay, and you can't tell me what that family member told you because that's hearsay. You
Correct.
understand that. Okay, so she called a family member, and that was on September 4th.
Yes.
Okay, a family member called you.
The family member actually...
Did what?
Actually lives with me. So they didn't call me.
Okay, well, you can tell me the relationship.
It's just family.
Okay, family member who lives with you, and?
Yes. So she was calling that family member, asking for...
You can't tell me what any of that was about.
I'm sorry. So after the conversation with the family member told me what she said. I know, I'm not saying the conversation.
Absolutely right.
So I told Brandon what she said, and we thought at the time, let's have an intervention.
Okay, now, so without giving any credibility to any out-of-court statements, I assume by the word intervention, you had a suspicion that the defendant was using drugs or alcohol.
Yes.
Before that, before September 4th, did you have any knowledge of ongoing substance abuse with your best friend?
Yes.
Since when?
For a very long time.
Okay. Did you ever discuss the drug use with her?
Yes.
Well, you can tell me what those discussions were like. What kind of drugs were you afraid she was using?
I prefer not to say.
Well, you can't not say. That's what this is all about. You wanted to have an intervention. You didn't want to have an intervention because she was having caramel-covered popcorn. There was a controlled substance, I assume, that you were afraid she was using.
Yes.
Which was what?
Cocaine.
Have you ever seen her using cocaine?
Yes.
Did you ever use cocaine with her?
Yes.
Between May and September, had you ever used cocaine with her?
No.
So it was before that?
Yes.
His name is Brandon?
Yes.
Had Brandon ever used cocaine with the two of you?
No.
Did you ever see Brandon use cocaine?
No.
Okay. So you, who had used cocaine with her, decided to have an intervention with Brandon?
Yes.
What do you do for a living?
I'm an inbound call agent. I sell tickets.
Okay. And what does Brandon do?
He's disabled.
And who was going to be at this intervention?
It was myself, Brandon, and another mutual friend.
Mutual friend. Now, this mutual friend, whose name I will not have you state, have you ever seen that mutual friend use any sort of controlled substance? Answer the question.
Yes.
Yes. So now you have two people who've used controlled substance, one who has not, to your knowledge, doing an intervention.
Correct.
Okay, and do you know what an intervention is?
Yes.
What is it?
It's basically a meeting of the minds of having a discussion with one person about an issue that...
And who's there?
Who's there?
Yeah.
Oh, I would say trusted people that I would feel that they were...
Sarah, I want you to look up the word intervention and read me the very, very simplistic definition of an intervention.
From the Mayo Clinic, an intervention is a carefully planned process that may be done by family and friends in consultation with a doctor or professional, such as a licensed alcohol and drug counselor, or directed by an intervention professional called an interventionalist.
Okay, so what you don't have is something, I assume, this conversation occurred on September 4th.
Correct.
Was it on that same day that you decided to have an intervention?
Yes.
Okay. So let's start with the word well-planned, not as a result of a conversation that you have with somebody. And it's a well-planned event done in conjunction with very often relatives or close family who have a concern that something is out of control, some abusive behavior that's related to either alcohol or other controlled substances, in conjunction with a licensed professional where everything is synchronized, but managed by a professional. Do you understand?
Yes, this was a bad plan.
If there was no plan, it was a plan made because you were annoyed. Usually people who are involved in thinking about an intervention have nothing but love in their heart for the person who needs that intervention, but they have a plan. You didn't have a plan.
Yes,
you kidnapped her into your house.
Jennifer Paramon claims her former friend, Cardi Moran, broke her television. Cardi is countersuing for emotional distress.
Now, you were annoyed at the conversation, so what you did was not really an intervention. What did you think was going to happen at the end of this intervention? What was supposed to happen to her? According to what I read, you called her, or someone called her, probably your family member, called her with regard to these drugs that she wanted to purchase. Is that what happened?
Yes.
And said, I have them, come to the house.
Yes.
Okay, so that's not a giant leap. You have to put that together. So she calls your family member for some cocaine. You arrange for an intervention. Your family member calls her at your request and says, come to the house. So that's what happened.
Yes.
Okay, but she was lured to your apartment.
Yes. Yes, I was.
Yes.
By whom?
By us. By her.
What do you mean by us?
They all
myself.
Shut up.
Myself, Brandon, and another
Well,
mutual
who
friend.
called her and said, come over?
Who called her?
Yes.
We were already going out. She was already going out with Brandon.
Just a second. She was already going out with Brandon.
Yes. And she decided to come to where I live to come pick up these drugs. Because when she found out that basically the setup was for her to get her to my house. So I told my family member to tell her that we did have it.
Oh, just a second. That's what I said. So she was lured to your house.
Yes.
Where you were going to do what with her? What happened when you got to your house?
Basically just talk.
Not basically.
Sorry.
Not basically. You lure somebody to the house. She's come to the house now expecting, let us say, expecting to buy drugs or get drugs. She gets there and realizes that that's not going to happen, that there are other people that that's not going to happen. So tell me what happened when she walked in the house. That's what your case is.
Well, when she walked in the house, I immediately tried to give her a hug, and she was upset.
No, you immediately tried to give her a hug. What did you say?
I didn't say anything. I just opened arms, and she said, no, it's fake, backing away.
It's fake. What's
Yes.
fake?
My hug.
Okay, so she backed away.
Yes.
And
it just started off with
No. Somebody had to say something to her. Somebody had to say this is an intervention. Somebody had to say why she was there. She eventually was going to say, where are the drugs? But you have to tell me what happened.
Yes, when she walked
in, you went to give her a hug, pushed you away. Then what? Come on, this was an intervention.
Yes. So we couldn't even get to the part of this is an intervention.
How could you get to an intervention? You don't know what an intervention is.
Well, we couldn't get to a part of let's talk. She immediately said she was being set up. This is a setup with arguments back and forth.
Well, what were the arguments back and forth?
The back and forth arguments.
She said, I'm being set up. Somebody said to her, this is an intervention.
We didn't get to that part.
Well, what is the setup that she was talking about?
I don't know why she said.
Well, it was a setup.
It was a setup. It was a setup.
Yeah, so I want to know what your end game was.
The end game was to have a conversation with her so we can resolve our issues of why does she need an apology from me? We have been friends for so long. Her getting to my house, yes, we did lie and say, yes, there was drugs at my house. But she already knew from how we're all there that there was no drugs. She was upset. She was irate. She was bringing up the argument that we had earlier in the morning.
So this wasn't an intervention for drugs or alcohol?
It was an intervention for drugs and alcohol.
Oh, okay. Then I'm asking you, not what happened, what was your end game?
The end game was to have a conversation with her about how much drugs she was doing because it changed her mood. It made her angry.
Well, did you have a program for her to go to? Did you have a program to take her to? Had you spoken to a professional? Had you done anything?
No.
Okay. And when she was there, according to you, she was in your house with 3 other people?
Myself and Brandon and another mutual friend.
So with 3 other people,
yes.
So she was there with 3 other adults.
Yes.
And she was lured there under false pretenses.
Yes.
And what she did, according to you, was pick up a chair and throw it at you, or threw it at a television set, breaking the television set.
She didn't throw it at me.
What did she do?
She threw it directly at my television.
Lucky she didn't throw it at you?
I wish she would have.
That's
exactly what she did.
Just a second. You're lucky. You can't do what you did. That's almost like kidnapping. If you're having a serious intervention, you have to sit down, have a working plan, what happened, have the right in your heart, have the right messaging. Your messaging was all wrong. Usually people who are involved in thinking about an intervention have nothing but love in their heart for the person who needs that intervention, and they seek professional help in order to get that person professional help. But they have a plan. You didn't have a plan.
Yes,
you kidnapped her into your house.
It was
you
bad.
Can't do that.
It was bad. It was
very bad.
Yeah.
So you fix your own television set. Your case is dismissed.
But Your Honor, I have it all on video.
Did she break your TV?
Yes.
I'm going to look at the video. Your case is still going to be dismissed. I believe she broke your TV. Show me the video. I believe it.
And I also have
I believe that you're lucky that's all she did in order to get out of your apartment. Did she ultimately leave your apartment?
Forcefully,
yes.
I kicked her out.
So forcefully, you tricked her into coming in, and then you kicked her out?
Yes, after breaking my property.
Okay.
Yeah, but why are you like I squirt the dog? I cannot. I said, Jack, are you serious?
I'm ready.
Are you serious?
Why am I being recorded?
Just a second. I don't know why you're being recorded. In any event, as I said, your case is dismissed. Fix your own TV. You have a counterclaim.
Yes.
And your counterclaim, I don't know what this speaker is. What is a speaker?
A speaker, you connect your phone to Bluetooth and you hear music on it.
Okay, so what was it doing at her house?
Shh. We were supposed to be hanging out. So I was supposed to be hanging out with Brandon and another mutual friend. I didn't know we were going to stay at Jennifer's house.
Okay, I just want to know what, you brought the speaker?
Yeah, a speaker.
And you left it there?
I didn't leave it there. My things were scattered. When she was kicking me out, my things were scattered, getting kicked into the hallway.
When amateurs decide to do an intervention, any negative consequence that flows from that, you just have to accept.
But that's reason for her to break my stuff?
Absolutely. It would have been reason to her to break everything in your apartment to get out.
Jennifer Paramon has accused her former friend, Cardi Moran, of breaking her television. Cardi claims Jennifer caused emotional distress after being tricked by Jennifer.
Okay. Did you look for the speaker?
Yeah, I looked everywhere in the hallway.
Do you have her speaker?
There was never a speaker.
Did you see a speaker?
No,
Okay, there's no speaker. Now let's talk about your emotional situation. You got to this, I can't even call it intervention. Trap. That's a good word.
There you go.
That's a good word. Thank you. And tell me what happened when you got there.
When I got there, I asked her family member to come downstairs.
Okay. Miss Moran, you walk in the door.
Yes.
And there's no question that you were tricked and that this was a trap.
Yes.
That's what it was.
I realized that maybe 1 minute
Okay.
That's what it was. Got in there, and it was an uneasy feeling. You realized that it was a trick to get you there. It was a trap. I want you to tell me what happened when you got inside.
Jennifer starts to walk up to me, like, with her arms open, real slow motion, like, Cardi, I'm sorry. You know, we should talk about this. We're friends. In that same tone. And I'm like, yo, really? You're being fake. I don't really want this. You know, I came here to get what I wanted, and let's go. But Brandon is getting all comfortable. He is disabled, so, you know, all right, fine. He's got to get comfortable. So we start arguing, me and Jennifer, we start arguing.
About what?
About the conversation that me and her had earlier. You know, she said that I should just get over what she said initially for me getting upset.
Okay, so the initial conversation didn't have anything to do with drugs?
We never talked about drugs. When I got to the house, I never had anything to do with them. I was talking to the family member, what I came to get. Then once me and her start arguing, I tell Brandon, like, all right, can we go now? Like, are we done here? Like, let's leave. I want to go.
So what happened? When you said to Brandon, let's go, I want to get out of here, what happened?
She squirts me with a water gun. She tells me, oh, I'm gonna squirt you like I squirt the dogs.
Brandon, stand up. Your last name is?
Milman.
I want you to describe this water gun.
To be honest, Judge, I don't remember seeing a water gun.
It's in the video. If you listen to the video, she says it. I'm gonna squirt you
Brandon,
like I squirt
before
the
I
dogs.
look at this again, you were there in the room.
Yes.
I'm going to give you one before I look at the video again. Whether you saw her squirt the water gun or not, did you see a water gun that day?
No, I didn't.
No, okay. So let's play this and let me hear what you're referring to.
Why squirt you like I squirt the dog? I cannot. I said not. Jack, are you serious?
Okay, Sarah, you have a much more keen sense of hearing than I do.
I'm going to squirt you like I squirt that dog.
Okay. She's got younger ears than I do. What?
I never squirted her with the
Whether you did or not, are you telling me that?
No, I
that
said
Sarah
it.
heard. Okay, so you did squirt it.
But I
You
didn't
say
squirt
it.
her.
I'm going to squirt you like I squirt the dog. Yeah. Okay, but that's not an intervention.
We were arguing at that point. It was already past the
that's because you lured her
conversation,
there.
intervention.
Because you did the wrong thing.
Yeah, it was a horrible plan. It was horrible.
Oh, yeah, they're absolutely right. And it caused a great deal of distress. I want to know how you got out of the apartment.
I was kicked out. I was pushed out. My things were thrown into the hallway.
At what point did that happen? Is that after?
Literally 3 seconds after.
After the TV was broken.
Yes.
You were pushed out the door.
Yes.
Well, that's some really good intervention. How long were you in the house?
A total 6 minutes, maybe.
Where did you go from there?
I got picked up and went home.
Got picked up by whom?
2 hours later by my sister-in-law.
Don't make anything up.
No.
Who picked you up?
My sister-in-law.
Okay.
And my daughter and her boyfriend.
In that 2-hour period,
Yes.
you must have waited somewhere for them.
Yes, I waited in her hallway.
Okay, so you waited. When they came to pick you up, was there any further conversation with her or Brandon? They just picked you up.
Well, between those 2 hours, there was conversations between my daughter and Brandon, my daughter and Jennifer. Everyone was talking.
Well, where was your daughter?
She was home.
So it was on the phone that they were talking?
Yes, and she was pleading with them to give me my stuff back so I could just leave.
The cross complaint, or the countersuit, is seeking $1,800. It's seeking $1,800 not only for the emotional distress that was caused to the defendant, but also for a speaker. They don't have a speaker. How much was the speaker so that I can deduct that?
It was $129.
Okay, so we're really talking about $1,700. Okay, and that's the amount that you want for your emotional distress.
Yes, Your Honor.
For that 6 minutes. I don't blame you. I think it's worth at least that. I think that when amateurs decide for all the wrong reasons to do an intervention, any negative consequence that flows from that, you just have to accept.
But that's reason for her to break my stuff?
Absolutely. It would have been reason to her to break everything in your apartment to get out. Absolutely. You are holding her there. Yes, just a second. You brought her there under false pretenses. That's what you did. And you had somebody else there as well. And according to you, you wrote it was an intervention. But it wasn't an intervention. It was whether you wanted to
For a 20-year relationship, I made intervention may be a wrong
Well,
word,
it
but
was a very,
supposed to be
it was a very,
conversation.
very wrong word, and you don't trick somebody to come to your house with something else in mind, even if it's to buy drugs. So I'm awarding you $1,700 on the counterclaim for your emotional distress. Your claim for the broken TV is dismissed. We're done.
This court is adjourned.
I have no thoughts.
I'm happy with her decision, but it's bittersweet because these are my friends.
Just have a conversation about certain situations we were having.
Her intention, I don't think it was to make me stop doing what they all do anyway.
I didn't keep her, that's the thing. She walked in freely, walked out.
That's the betrayal.
Yeah, this is over.
It's just time to go separate ways. You know, I lived and I learned those are the people that I grew up with. You know, those turn-up days are over anyway, so.
I think this whole situation was a perfect example of what my dad calls lack of two-step thinking.
Okay.
So we can already agree the intentions were not great. They were just maybe potentially rekindling a friendship, and that's not exactly the person you want leading your intervention, if that's what they wanted to call it. And also, what was your plan? If it went the way that the plaintiff at least claims she was intending it, was to get her friend help, say that the defendant broke down and cried and admitted to having a problem and really wanting help. Where was the help? There was no help.
That's true.
So I agreed with you that the plaintiff deserved any amount of damage that happened from having such a lack of a plan.
It was a lack of a plan. She lured her there.
Yeah, I mean, just a messed up situation all in all. And you really have to be coming from the right place to do something like that. And I think neither of them.
Have a seat. Jones, you and the defendant were in a romantic relationship that started about a year ago, more than a year ago. And then you decided to do one of the most foolish things that people do when they sort of fall in love, sometimes temporarily. You decided to buy a dog together. According to you, the relationship went south, and now we have this adorable dog that you want back. You say the dog is really yours. You were the one who was its primary caretaker. You paid for a vet bill. Mr. Caldwell said that's not the case. The dog was always supposed to be his. He purchased it, and it's your argument that if Mr. Caldwell is allowed to keep the dog, that you be reimbursed for the vet bills that you paid.
Yes, ma'am.
Okay. Did you and Mr. Caldwell live together?
Yes.
From when to when?
From February 1st of this year to September 3rd.
And in what month did you decide to get the dog's name is Scrappy?
Yes.
Scrappy.
We got Scrappy on January 18th.
So before you moved in together?
Yes.
Where were you living?
I was going back and forth from my mom's house to Joshua's. I already had a key in January. I was staying there.
Okay, but you were living with your mother.
Yes.
In January.
Yes.
And who was the breeder of this dog? Did you buy the dog from the breeder or from?
From the breeder, Andrew.
Now, Andrew was sitting over there on the defendant's side, so I assume that Andrew was a friend of your boyfriend's.
Yes.
Stand up, Andrew. I have a couple of questions for you.
Okay.
That's Scrappy.
Yes.
Scrappy is about 8 months old?
He just hit a year about 2-3 weeks ago.
Oh, so still a puppy.
Yes.
Looks very healthy. When Scrappy was purchased, was the amount paid for him the same as was paid for the other dogs in Scrappy's litter?
No.
How many puppies were in the litter?
5.
Did you charge Mr. Caldwell or Miss Jones for Scrappy?
Mr. Caldwell.
How much did you charge him?
$3,000, Your Honor.
Who paid you?
Joshua.
Mr. Caldwell, did he pay by check or cash?
Cash and Zelle payments.
Did you ever see Miss Jones in the purchasing process?
Yes, I seen her.
Tell me about it.
At the time when they came to pick up the dog, she was his girlfriend, but there was no connection with me.
Was that the first time you had met her?
I've seen her around because we would work at the gym together. We're both personal trainers, so I would see her around the gym sometimes.
Had you discussed with your friend Joshua?
Yes.
While you were working with him in your personal training at the gym, had you discussed with him getting a dog?
Yes.
When?
I can't recall the exact date, but I know that he had seen that I had bought my dog and that I was getting into the business. So he contacted me early in, say, 2020, stating that, hey, I want to eventually, when you have a litter, get one of your dogs from you.
Do you remember what month that was in?
I'd say, well, Scrap was born October 2021. So around then, maybe a couple months before when I let him know that the female was pregnant. So maybe around July, August.
Okay. of 2021?
Yes, Your Honor.
Okay, so that was well before the two of you lived together.
Yes.
Did you ever hear from Miss Jones? Did she ever call you before you saw her when they both came to pick up Scrappy?
No, Your Honor.
Okay, you can sit down now. Cute. Miss Jones, who paid for Scrappy?
Me and Joshua.
Show me.
I have here Zelle and Venmo payments to Joshua. The first one is in February, and then he didn't start asking me for large amounts.
Hold on 1 second. Hold on. These don't look like anything like payments for the dog. What are those payments? $100, $500, $350 in June. What were those for?
They were all payments towards Scrappy. He started asking me for $200, $350 at
You mean
that
after
time.
you already had the dog?
Yeah.
Because you got the dog.
Yeah, but he didn't pay for him straight up. And his friend told us that we could pay for him at will. He didn't give him money the first day that we picked him up.
Okay, I'll go back to you. How much money did Mr. Caldwell pay on the day he picked up the dog?
$0.
When was the first time he made a payment? Now you could stand up again.
He made a payment shortly after, within the first month, of about $300.
So in January, he made first payment.
Of $300.
And in January, there is no Zelle payment from you at all. When was the next payment? Do you recall?
I believe in March he paid another $200.
Well, do you have records of what you paid, sir?
Yes.
I'd like to see them. I just want to see what you paid and when you paid it. By the way, while he's looking for that, when you lived with Mr. Caldwell, did you both contribute to the rent?
My contribution to the rent was paying for the groceries, so I have all my receipts.
So the answer is you did not pay rent.
That was our deal.
But the answer is you did not pay rent.
No, ma'am.
Did you pay any utilities?
Only when he asked me for extra money to pay his phone bill or to pay for the Wi-Fi sometimes.
And when you paid for these extra things, Wi-Fi or his phone bill, did you pay by cash or did you pay by?
The extra charges in there that I didn't highlight. The ones that are $20, $30, those are for gas. The $70 one is for his card.
Well, I just want to know how you know the payment in July for $200, what it was for.
I was only giving him money at that time. For Scrappy, he started asking me for large amounts of money for him. So that's when I gave him those. He didn't ask me for anything towards bills for that apartment.
Is Scrappy totally paid for?
No.
How much is owed?
$2,300.
So the only amount that was paid so far was $700.
Yes, Your Honor.
This is what happens, because relationships come and go. You know, 50% of the marriages in this country fail. So why would you think a relationship is going to last as long as a French bulldog?
Jasmine Jones claims her ex-boyfriend, Joshua Caldwell, owes for the costs of a French bulldog. Joshua is countersuing for vandalism and an assault.
Okay, and this is an agreement that I, Joshua Caldwell, have agreed to buy Cashmere.
That was his name originally.
From Frederick Wright. Once the dog's paid in full, I will receive full ownership rights. Frederick Wright will remain the rightful owner of Cashmere until I complete $3,000 in payments, right?
Correct.
And both of you signed this, and this was in January of 2022. That's a reasonable. What are you laughing at?
I'm not laughing. I'm just like, when did he even sign that? Because I was with him the day that we picked him up, and he never showed me any contract.
Well, but this is reasonable because he's not transferring any rights to him. He's going to remain the owner. He's the owner of the dog until the full amount is paid for the dog of $3,000. Right now, he said that the only thing was paid was $700. Go ahead. Now I'll hear you. Now I got it. Now you can sit down.
When I was present for us picking up Scrappy and purchasing him, it was word of mouth contract. There was no paper signing at all. He didn't even show me a paper.
And?
And he showed me him. He asked me if I liked him. I said yes. And he said he would go half on him with me.
Okay.
And I said, okay. And it was that same day. I get off of work. He picks me up. We go see Scrappy. Didn't know we were going to get him that day. We ended up getting him that day. He tells me, okay, it's just going to be $3,500. They walk to the back of the room and start talking and making an agreement. Come back out.
So just a second. So they went in the back of the room. You were not there. That's what you just told me. They went in the back to make an agreement, and then they came out. That's what...
He tells me it's going to be $3,500. They walk to the back of the room, make an agreement.
Right. Go ahead.
And then he comes back and we take Scrappy home. The next day, he texts me early in the morning and tells me that Scrappy might have gotten a bee sting or something because he was limping and he doesn't know what happened. I picked him up from his job that afternoon after I got off of work.
Okay, so you picked up the dog from his work.
Yes, picked him up and I went straight to my mom's house to get clothes because I was going back to his house. And I was examining Scrappy, no swollen paw, no bee sting. Then he said that he probably clipped his nail on the tile, and I'm just like looking at his paw and I'm like, there's nothing wrong with it, but he's limping. Those were his stories. Still don't know what happened. Scrappy wasn't showing any signs of like pain, he was just limping. So I was like, we need to take him to the vet, like he needs to get checked out.
So you took him to the vet, okay,
Yes.
and?
The vet ended up telling us that he had a fracture.
You can't tell me what the vet told you. I'll look at the records from the vet.
Okay, sorry. I have the vet bills and the reports right here.
Did you pay any part of these vet bills, sir?
Yes.
Which parts?
I didn't have any record of it because I didn't see it coming. I honestly didn't know what happened to his elbow. Andrew was there as well. We were both kind of like, we don't know. So I found out after going to the vet that Frenchies have a ligament in their elbow, and this happens often.
No one is suggesting that anyone abused the dog.
Okay. Oh, I'll just.
That's not the suggestion. My question was a simple one. Did you pay any of these vet bills? They're about $1,600.
Yes. I just don't
How much
have
did you
any
pay?
record of it.
What?
'Cause
He's lying.
I didn't ask you to interrupt. You have to understand, Miss Jones, you can't have this dog. First of all, this dog doesn't belong to either one of you. This dog belongs to him until the dog is paid for. So far, all he's gotten for the dog is $700. $500 of that he paid for. But right now, I can't award ownership of the dog. There's a contract that until this dog is paid for, the dog belongs to Mr. Wright. First name?
Frederick.
Frederick. You understand?
Yes, ma'am.
Simple. So you have a friend who has Frenchies, then I suggest that you go with your original plan, which is to buy a dog yourself.
Not
Now,
the same.
you have no proof that you paid any of these vet bills.
I just have the medicine with my name on it.
Well, the medicine with your name on it doesn't help. $1,600 in vet bills. And you have physical custody of the dog now, right?
Right.
And your agreement with Mr. Wright is that you don't get ownership of that dog until the dog is paid for. Yeah, I mean, I can't enforce your contract with regard to Miss Jones. The dog was not paid for.
I've already offered to pay him for the remainder of whatever Josh hasn't paid him.
The contract is with Mr. Caldwell, not you. So that's what happened when foolish young people decide to own a dog together. And they're not married, they don't even live together. This is what happens, because relationships come and go. You know, 50% of the marriages in this country fail. So why would you think a relationship is going to last as long as a French bulldog? It's sort of ridiculous, and I've advised against it for the last 25 years. Nobody wants to heed this. So I'm faced with a situation where, when did the two of you break up?
I left it on September 3rd.
Well, now we're a couple of months, but...
She didn't leave. She had to be, well, this is going to go into the assault charge.
I don't,
But
listen,
she had
I
to
don't
be
care.
escorted
I don't
out.
care, whatever. If,
I
don't care. You want
clothes.
I'll get to the counterclaim in a second. I will give it the same attention as I've given her claim for the dog. She's not getting the dog back. You have to, however, pay her the $1,600 that she paid for the vet. Do you understand? So that part of your petition is granted. Was the bill all paid?
I'm still paying it off currently. We both agreed to apply for care credit together, and whoever...
But it's your bill that you have to pay. If you work in accounting, you have a check, you don't want that garnished, so you have to pay it.
I am paying it.
You have to pay it. Okay. And he's going to reimburse you for that, $1,600. All right, now let's get to this counterclaim and make short shrift of it. Money owed for assault and vandalizing personal belongings. Let's start with the assault. Allegedly, the assault took place when the plaintiff came home intoxicated.
I'm a kickboxer. On September 3rd, she came to my fight and she dropped me off at home.
That's a lie.
If you say it again, what I'm going to do, if you interrupt Miss Jones, again, what I'm going to do is I'm just going to dismiss your claim and you'll pay for these vet bills yourself. Do you understand?
Yes, ma'am.
Okay. Go ahead.
She didn't like the people that was at my fight there, and so she had a couple drinks. She got to my house, and she started to fight with me, and I tried to remove myself from the fight, and then she started getting violent. So then I called her family to come pick her up, and they showed up maybe an hour later. In that hour, I tried to remove myself to another room. She went and got scissors and started to cut my shoes up. Then I had to try to grab my shoes and scrap and go into the opposite room, and she came in there and was trying to fight me. All the while all this happening, I'm recording her on video to make sure that I'm...
You have that recording?
Yes.
I'd like to see it.
This would be me asking her just to leave. This whole thing is out of retaliation. What are you about to do? Why are you hitting me in the face?
Record me because I want my dog.
Fighting me. She won't stop fighting me. I've asked her to leave.
Explain that to me.
Jasmine Jones is accusing her ex-boyfriend, Joshua Caldwell, of owing vet bills for a French bulldog. Joshua is countersuing, claiming Jasmine assaulted him.
Okay. You have that recording?
Yes.
I'd like to see it.
This would be me asking her just to leave. This whole thing is out of retaliation. Why are you hitting me in the face?
Record me because I want my dog.
Fighting me. She won't stop fighting me. I've asked her to leave. Your stuff is in bags.
You're such a... Josh.
Okay. There you go again. There you go again. On camera hitting me. On camera hitting me. On camera. You see her hitting me? There you go.
Explain that to me.
I wasn't dropping him off. We were still...
I don't care what you're dropping off. Explain that video to me.
I was pushing the phone out of my face because he had me on live and was saying my full name. He cut off parts of it.
No, I just want to know what happened here. This was clearly you were going after him. I don't know whether you...
knocking the phone out of his hand because he was saying my full name, saying I was crazy. I had already packed my stuff. I was leaving. We walk in the house. He calls me a dumb bee and then goes straight to the bathroom. I'm like, okay, well, I'm just gonna leave. Like, I'm not gonna deal with this. I had Scrappy by my side. I was packing what I could, taking it downstairs. I walk back up. He goes, oh, you're leaving? And he snatches Scrappy and locks him in the bedroom. And then when he goes to open the door is when I barge in. I'm just like, give me my dog so I can leave. And
well, I want to know what the violent stuff was about.
He was recording me, saying my name.
He was recording you.
Saying I was crazy and I wouldn't get out of the house. And I was like, stop recording me. And I was just hitting the phone out of his hand. I never once put my hands on him. He's already hit me and choked me in the past, so I would not go there to provoke him to hurt me again.
Did you ever report to anyone that he hurt you?
I told my mom.
Did you ever report?
No, I didn't.
Mr. Caldwell.
Yeah.
Were you injured?
I mean, I'm a fighter. I'm not gonna...
Were you injured is my question.
No.
Her family came?
Yeah.
The police were not called. You called her family instead. Did you pick her up? Stand up, please. You're a mother?
Yes, I am.
Okay. And this incident happened on what date when he called you?
It was about 3 o'clock in the morning.
Right.
On...
Shh. Don't interrupt. On what date?
Labor Day.
Did you go to Mr. Caldwell's home?
Yes, I did.
What time did you get there?
Probably almost 4.
Had Mr. Caldwell ever called you before with regard to picking up your daughter or that she was... No.
No.
So this was a first?
Yes.
Now, when you got there, I want you to describe what you saw.
She was crying, she was upset, and I told her, come on, let's just go. And she said, no, I want to get my dog. I can't leave my dog here. He's been violent in the past. I've seen it. I told her, don't ever leave him with him again after a beach incident where he, like, hit him. I mean, he's a kickboxer, like he said. He doesn't hit the dog like a normal person would just tap a dog. No, this was back in July. He was a puppy. He was a baby. And I was so furious when I saw that. He only did it because the dog snapped at him, because he was angrily packing him up into a dog carrier.
Would you do me a favor? Would you describe to me your daughter's condition?
Oh, I'm sorry. I'm sorry.
Describe to me. You have to understand. Your daughter cannot get the dog. The dog does not belong to the defendant.
Okay.
The dog belongs to Mr. Wright.
What happens to the $1,310 she spent for the dog?
Well,
she sent that money to him.
I have to tell you something. I don't see anything in your daughter's evidence that suggests to me that any payments that she made to him had anything to do with the dog. Anything to do with the dog. Mr. Wright was very clear. He said he received $700 for the dog. There were 2 payments that were identified in his register as payments for Scrappy. There is absolutely nothing in your daughter's register that she gave me of these odd payments of $160 or $70 say Scrappy on it. Not one. So I've already made a determination of where the dog is staying. The dog is staying wherever Mr. Wright wants the dog to stay, because he owns the dog.
Okay.
Understand?
Yes.
So now that's your daughter's case. I finished that part of the case. What I want to know is he has a counterclaim, and his counterclaim was that your daughter, while in an intoxicated state, assaulted him. Some of that I saw on this video. Some of it you saw on the video. Mr. Caldwell was honest, because it doesn't look as if he was injured as a result of that, and I'm absolutely not discounting the fact that no one should put their hands on somebody else, but an assault requires an injury. And so if this is is that dog sleeping?
No, that
is so funny.
He grunts all the time.
That is so funny. So, Mr. Caldwell, can you show me what damage you allege Miss Jones caused your property? That's the next thing. You said an assault, which never happened because there was no physical injury. Would you mind telling me, please, what property specifically and photographs of that property?
I'll have it.
Okay, so your counterclaim's dismissed. Judgment for the plaintiff in the amount of $1,600 for the vet bills that she paid or is obligated to pay on her credit.
It's not assault unless I get hurt.
Yes, it's not an assault unless there is an injury.
So if I was
that it's an
beating
attempt.
her up at her
Just a
house?
second. That's an attempted, sir. It's an attempted assault. Do you understand? If an assault has a specific definition, I believe she probably attempted to assault you when she touched you in an unauthorized manner.
She was punching me in the face. That's not a...
Show me picture of any injury. Show me. No, I didn't see that in the video, sir. I saw her lunging towards you. Do you understand? I saw her lunging towards you. I didn't see her hit you. I didn't see a photograph of any injury. I didn't see a police report where you reported any injury.
Report incidents with her being drunk and fighting other men.
Oh, okay. Did you understand what I said? An assault requires injury. An attempted assault does not. And attempted assault is a crime. But it's a crime which I choose, because of the circumstances here, not to consider and not to award you any cash award because you were not injured in any way. So unless you have photographs of the pair of shoes that you say she cut or something else, I'm dismissing your counterclaim. We got it? Good. Okay. Judgment for the plaintiff in the amount of $1,600. Thank you very much.
This court is adjourned.
Scrappy was not just like a dog or a pet, like he was my support.
I mean, it was fair. Obviously, she had nothing to do with the dog.
It's expected because he lied the entire time that we were together.
And that's a lie.
Him not to have given him any of the money that I put towards Scrappy.
She literally just got all the transactions that we've ever done between each other on Venmo or Zelle and brought that to court.
Now I just think like he was pocketing that money the entire time.
And that's why it was dismissed, because it wasn't valid at all.
I disagree with you a little bit on the countersuit of the assault charge. I have a more, I guess, broad overview since I'm just out of school with the common law. So assault versus battery, as far as I learned, was assault was just the imminent threat of a harm. You're fearing for your life or offensive contact of some sort, whereas battery is the actual offensive touching. There has to be some sort of contact. So if we're ruling by common law, which I know we're not bound by any particular state's jurisdiction, I would have awarded him something for the assault claim.
My training is in New York, and in New York there is no crime of battery. My training was it's assault, and for an assault there has to be a physical touching and injury, and an attempted assault is placing someone in fear of imminent physical injury. I think you're probably right that there are jurisdictions that are different. We didn't actually see any contact between her and him.
And he was honest. He said,
yeah.
you know, obviously I didn't have any injuries, but...
Right, just as he didn't have any. Your sister is the person who stole your money, and the police were called.
She told me that I can use her card.
You're telling me that after she called the police, she still gave you permission to use her card?
Yes, Your Honor.
You're not going to end up well here. Do you understand that?
This is Judy Justice. Jada Maxwell, is suing her sister, Valastasia Maxwell, for unauthorized bank account charges and property damage.
Court come to order. All rise.
Have a seat, please.
Hello, Judge. Case 2191, Maxwell versus Maxwell.
Thank you.
You're welcome.
Miss Maxwell, this is your sister.
Correct.
Older, younger?
Younger.
The two of you decided to take an apartment together.
Correct.
When was that?
August 27th of 2021.
Were you both on the lease?
No, ma'am, just me.
How long did you live together?
It was about 6 to 7 months.
When did your sister leave? What month?
She left at the end of June of 2022.
June of?
2022.
Miss Maxwell, was it your arrangement that you would split the rent?
No. I would pay a portion of the rent, not split it even.
Well, tell me what a portion was.
The first month I stayed there, which was September only, I didn't pay anything. In October through November, $200, and then after that it was $400.
Well, how much was the rent?
$950, I believe.
And how many of you lived in the apartment?
Just us two.
Well, why weren't you paying half the rent?
I slept on a couch.
Oh, is that correct?
That is correct, Your Honor, except for the agreement. The agreement was that she would keep the apartment clean and pay half the rent and utilities.
Well, why would she pay half the rent if you get the bedroom?
It was her agreement. That was just...
No, I'm just saying, that doesn't sound reasonable to me. If she got the couch and you got the bedroom, why would she pay the utilities and half the rent?
Well, it wasn't... The rent itself was, like, she gave me what she could, but that was just our agreement. I bought the couch big enough so that she would be able to use it.
Nonsense. Okay, this is what the case is about. You claim that she stopped paying any money towards the apartment and you threw her out. And when she left, she damaged some property, and then she charged some money on either your credit card or a debit card.
My debit card.
Did you ever give her your debit card?
There was only one time when I handed her with permission to use the credit card at a gas station.
That's not true.
You had a physical debit card?
Yes, Your Honor.
Okay. And the one time that you let her use it, I want you to tell me when that was and what that was for.
It was within the time period of her living in the apartment. We were at a gas station and I was filling up. She went inside the gas station to purchase something because she didn't have money at the time, and that was it. That was the only time that I recall her ever giving her permission to use my card.
Okay. She moved out of the apartment in June of 2022, and I understand it was not an amicable process, and the police were called.
Correct.
Who called the police?
I did.
Why?
My dad gave me advice, and he said that I should call the non-emergency escort so that they can watch her, make sure that she actually leaves when she was asked.
And what day in June was this?
I do not recall the date.
You don't have a police report or a number?
Not for that. They didn't give me a police report for that.
Did they give you a police report for something else?
I have the police report for the fraud.
Oh, I'd like to see that.
Yes, Your Honor.
Because it is your claim that you used the information from your debit card and withdrew a lot of money from your debit card.
Correct.
So you reported this to the police on August 25th?
24th.
It says reported
okay.
8/25. How much money did she take out of the account?
At the time of that, it was only estimated about 10, but once the July statement came out, I was able to add up more, and it was nearly 14, 15 grand.
May I see it, please? How did you get her banking information?
I had to call them.
Shh. How did you get her banking information?
I don't have her bank information.
Well, you took money out of her account. You acknowledge you took money out of her account.
I only took money out when she gave me permission.
No. You acknowledge that you took money out of the account. I've read your answer. How did you get her account information?
She gave me her card on multiple occasions.
You mean after you moved out, she gave you her card?
No.
Shh.
Yes.
Do you understand? You're not going to end up well here. Do you understand that? Because if she called the police, to watch you, to escort you out of the house, there is no question that she did not thereafter give you permission to use her credit card or her debit card. That doesn't make sense.
She did.
Do you understand the chronology of what I'm saying to you?
Yes, Your Honor.
So if I were to believe you, the only time you used her credit card is when you were still there. And that was prior to June of 2022.
That's incorrect.
My grandmother passed away in August
August 9th of 2021, and she was my legal guardian to the age of 18, so I was under her account as a beneficiary, so when she passed, I got the money.
Jada Maxwell claims her sister, Valastasia Maxwell, wrongfully took money from her bank account and damaged her property.
There is no question that she did not thereafter give you permission to use her credit card or her debit card. That doesn't make sense. Do you understand the chronology of what I'm saying to you?
Yes, Your Honor.
So if I were to believe you, the only time you used her credit card is when you were still there, and that was prior to June of 2022.
That's incorrect.
Just a second. So you're telling me that after she called the police to escort you out of the apartment, she still gave you permission to use her card?
Yes, Your Honor. I still went over to her apartment until July 15th.
For what?
I had my stuff there.
Just to gather your things.
And she let me use her car multiple occasions to get some of the furniture that she let me have. And she told me that I can use her card.
When was the last time you visited with your sister? July what?
July 15th.
And when was the last time you used her card?
July 16th.
What did you use her card for, July 16th?
Rent.
Between what periods of time did you use her card? Give me the dates.
Since September of 2021 until July 16th.
September of 21. And what was it for in September?
She would send me to the store, or if I was already at the store in her car, she would tell me to use her card or something like that. She would pay me to.
How much did you spend on her card just for you? Just for you, not for joint, not send it to the store. Here's my card.
I have it here.
Tell me how much you spent on you.
I'm not sure of the exact amount.
Did the police contact you with regard to the fraud?
No.
They never did?
No.
The police report, do you name your sister as the person who stole your money?
Yes, Your Honor. The bank told me...
No, don't tell me what the bank told you. Bank doesn't tell you anything. Would you show me here, maybe I'm missing it, where you report the person who took the money out of your account?
That is the only document when I went down to the station that they gave me. When I went to actually make the file, she just asked me a couple questions, who I thought was.
Don't tell me what somebody else asked you.
Yes, Your Honor.
Did you report to the police that it was your sister who fraudulently took your money?
I did, but the police eventually, they cut it off because I was going to pursue small claims. They told me that they are no longer needed.
Small claims. Why were you going to pursue small claims? How much money does she have? Miss Maxwell, let's get it together. Let's get it all together, okay? You were not going to pursue small claims because you knew that in small claims you would end up with zero. You knew that.
At the time, I didn't understand what everything meant, which is why I tried calling a bunch of people, and I spoke to,
No, I just want to know why, at this point, because the bank gave you back some money.
Correct.
How much money did the bank give you back?
I have it here. It was about $4,900, nearly $5,000.
Okay, and they gave you back almost $5,000. I'd like to see the communication with the bank. With the bank as to, if you are alleging fraud,
right.
If you're alleging fraud and you say that you had all of this money taken out of your account.
Correct.
Okay, then there's no reason why the bank, if you were alleging fraud and they found that there was fraud, why wouldn't they return all the money?
Because they have a policy that within the 3 months, they can only go up to the first 3 months. And because I didn't realize sooner, they can only go up to that 3 months. So they were only able to give me back within the transactions within those 3 months.
Is this a savings account or a checking account?
It was beneficiary.
What is that?
When somebody passed and you get money.
Explain that to me. I don't understand what beneficiary account is.
My grandmother passed away in August 9th of 2021. And she was my legal guardian to the age of 18, so I was under her account as a beneficiary. So when she passed, I got the money.
So you were living with your grandmother?
Correct.
Okay. And what was the benefit package?
What do you mean?
How much did you get as a beneficiary?
It was about 50 grand.
On what date?
I'm not sure when it was processed, but it was opened. Payment started of October of 2021. Or transactions
I don't
started.
understand what a beneficiary account is. Who paid the money? Who paid this $50,000?
My grandmother. She would put money in there so that if something were to happen to her, the money would go to me or whoever she listed.
Your Honor, it's a type of savings account. In simple words, a beneficiary bank account is a type of savings account in which the funds are transferred to somebody else after the account owner passes away, directly to the beneficiary.
Okay, this had nothing to do with you receiving benefits through your grandmother.
No.
This is an account that your grandmother set up for you.
Correct.
Now, is that grandmother also her grandmother?
Yes, Your Honor.
Did you have a relationship with your grandmother?
Yes, I did.
Did she only set up the one account?
I'm not sure, but I wasn't the only one that received money.
What about you?
Nothing.
Okay, so how much is left in that account now?
The account is closed out.
By whom?
At the bank. After a certain, once it goes under a certain amount, they send you a check with the rest of the money.
How much did they send you a check for?
It was about $200.
Well, who spent the $50,000?
I made transactions throughout the time period as well.
Okay. What did you buy with $50,000?
I just basically used it.
What does that mean?
I wasn't responsible with it. I'll be honest about that.
Did you know that your sister had this $50,000 amount of money?
I didn't know she had that much, no.
Did you know she had any?
Yeah.
Did you know where it came from?
Yes.
You have here July total $3,148.14. What does that number represent?
All transactions that were confirmed to be her added up total.
You can't use her credit card after you're not speaking to your sister.
Jada Maxwell has accused her sister, Velastasia Maxwell, of taking money from her bank account and damaging her property.
Now, what did you buy with $50,000?
I just basically used it.
What does that mean?
I wasn't responsible with it. I'll be honest about that.
Did you know that your sister had this $50,000 amount of money?
I didn't know she had that much, no.
Did you know she had any?
Yeah.
Did you know where it came from?
Yes.
Are you working?
Yes.
What kind of work do you do?
I'm a cashier.
And what about you?
I currently work at Chipotle and I also Uber on the side.
When was the last time you saw your sister?
July 16th. Or, I'm sorry, July 20th.
Are there any charges here after July 16th of 2021?
Yes, Your Honor. I actually gave that up already. In the top, it says July. It's written on there.
Just a second. I'm going to give this back to you.
Yes, Your Honor.
Find any charges that were made after July 16th. It was after July 16th was the last time you saw your sister?
No contact. We didn't have contact.
So the last time that you saw her was in July?
Correct.
You have here July total $3,148.14. What does that number represent?
That is that's the all transactions that were confirmed to be her added up total in just the month of July.
Were there any?
Yes, it goes in. If it goes.
Were there any charges?
There were quite a few.
In August, or was July the last amount of money that she took out?
In August, the card got cut off, so there were no.
Okay, so that the most that she incurred on the card in July was $3,000.
Correct, Your Honor.
And she left on July.
She was kicked out at the end of June.
The end of June?
Correct.
Yes, June of 2022.
Correct.
And that was with a police escort?
Correct. No.
Okay. Police watching you?
They left, and I was still in the apartment.
But they were there. They were called.
Right.
Okay. Now, what property do you allege that your sister damaged? Because that's the second part of your lawsuit.
It was a couch, and
What?
it was $1,100.
Well, I have pictures of the aftermath of when she was kicked out and what the state of the apartment was left in, including the couch.
Just show me the couch. If she damaged your couch, let me see it. I can't see what the damage is to this couch.
It shows better in other pictures.
Yeah, I don't see damage. I just see a lot of dirt.
Under the cushions, there was mold, and then there's a picture that shows 2 cigarette burns that her friend left.
Could you return this to the plaintiff, please? A lot of dirt. Okay. Anything else?
Thank you.
You can't use her credit card after you're not speaking to your sister. I don't believe
I didn't, Your Honor.
Yes, you did. $3,148.
I did not spend $3,000.
Kevin, these are July's statements. I think one of those things is yours. The bottom document. Okay, anything else? Judgment for the plaintiff in the amount of $3,148. We're done here. Thank you very much.
This court is adjourned.
There was a lot more to show, but I'm glad I got something back. She took a lot from me.
I don't see how you can decide I made a transaction with my name written in pen.
And caused a lot of downfall after the fact.
She's just mad, I guess. I'm not sure.
I almost ended up homeless. I almost lost my job because of this.
I didn't cause any damage, no.
It was very hard. I didn't even want to press charges because she's my sister.
Nothing. They pulled up. They said that I had to leave. And I said, no, I already paid my portion. And they said, okay. And they left.
No, she was kicked out prior to that.
My friend did do that. I can say that. But, like,
she's just lying.
I didn't damage anything.
At this point, I don't believe her. I don't trust her. She took advantage of me.
Hopefully we can just dead it, but I don't know.
So I'm just glad that I was able to get something back so I can continue to get back up on my feet.
One day at a time.
I'm hoping for an apology, some remorse.
Who knows?
After I confronted her and she admitted to it, she ignored and cut everybody out. She didn't even say she was sorry. She didn't speak to me.
I don't know.
You know, it's a little bit easier now to commit fraud using someone's credit card, even if you only had access to the physical card for 5 seconds. It's long enough to take a picture of the back and input all the information into the DoorDashes, the Ubers, all the accounts. And if you don't check carefully, you may not notice for a couple months. So, I mean, I've been a victim of fraud in that way, and I know it can be very stressful trying to deal with the credit card company, and especially when it's your sister. I mean, my sister better think twice before using my credit card.
Do you know, generationally, I have a problem. It's actually my problem because I'm used to writing out a check. I have a checkbook. I write out the check. I deduct the check from my balance. I know what is...
How they taught you in 4th grade.
Absolutely. You want to make a deposit in a savings account. We were taught you brought $2, you put it in a bank account. In the bank book every Friday, your teacher stamped it, $2. That's how you save money. And the fact that you can walk into a store and take your phone and go like that and charge.
And who knows whose information is on there.
Frightening to me. It all sounds as if it's going to collapse around me. But everybody, I think everybody who's under 50 uses that, probably more than 50, because my children are actually 50. It's hard to come to terms with that. But they all use their...
Online banking.
Banking?
Yeah.
I still don't have my banking online.
I know.
I still do. Yeah. I still call them.
Yeah.
They say, it's her again on the phone.
You know you could do this online now, right?
Yeah, no. Anyway.
Well, keep doing it your way, and hopefully we don't get ruined by our way.
Yeah, fingers crossed. She seemed like a decent young woman, the plaintiff. You know, it's sad. Her grandmother saved probably all of her life so that her granddaughter had a little nest egg of $50,000, and she blew through it. Blew through it.
Unfortunate, but I appreciate the honesty.
And it was honest. Put money in trust. That's my advice.
Suing his neighbors, John and Heather Gilbert, for truck damage.
Thank you.
You're welcome.
Mr. Gonzalez.
Yes, ma'am.
You're seeking substantial amount of money to to refurbish your car after it was hit by the defendant's car while your car was parked.
Yes, ma'am.
The defendants are seeking the same amount of money because they say that despite the fact that one of them did in fact hit your parked car, it was your fault. That's your defense.
Yes, ma'am.
Okay, who was driving?
I was driving.
Okay. Mr. Gilbert, on what date did this incident happen?
February 3rd.
What time?
About 5:30 in the morning.
Who was in the car with you?
Nobody. I was by myself. I was going to pick up my son.
You were going to pick up your son from where?
From his mother's house to take him to school.
And where does he go to school that he has to be there at 5:30 in the morning?
He doesn't have to be there at 5:30. I have to leave at 5:30 to get him there by 7.
Do you take him to school every day?
No.
What was different about February 3rd?
His mother, stepfather, and the rest of their family was out of town. They had asked me to take him to school that day.
Just for that one day?
Yep.
Yep is not an answer.
Oh, yes, ma'am.
Yes,
Yes,
is an
Your Honor.
answer. Okay, so it's about 5:30 in the morning, and?
I left my house. It was
Look at me.
raining. It was cold. It's pretty much the same route I take every day, not at that same time. I was approaching a stop sign at an intersection by the plaintiff's house, and I seen, I guess, either a reflection or what I thought were lights headed in my direction. So I swerved. And
Okay, you're still traveling, so you're moving. Does somebody have a diagram of where this happened? There it is. Okay. You were approaching a stop sign.
yeah, I was approaching an intersection.
So, right.
Were you there?
No, ma'am.
Sit down.
Yes, ma'am.
You were approaching an intersection.
Yeah.
It's a two-way road.
Yeah.
And it looks to me from that, is that an accurate representation?
Yeah, except for there was another vehicle on the other side of the road.
Okay, but it looks to me that you're traveling sort of in the middle of the road.
Yeah, it floods.
Okay, and a car is coming from something. You're not sure what.
Yeah, I wasn't sure what. It was
We're not
really
sure what.
And I swerved.
and
I
you-
just got over to the proper side of the road.
And your car swerved, and when your car swerved, it hit that blue car that's sitting there. That's the plaintiff's car that was sitting in front of his house.
Mm-hmm.
Uh-huh, is not
Yes,
an
ma'am.
answer. Yes, okay. Now, do you want to tell me what you did next?
I went through the intersection, turned around to follow what I thought might have been a vehicle headed my direction. And when I didn't see a vehicle, I took my vehicle home. I parked it. I got my insurance information, my driver's license, and I walked back to his house to trade insurance information with him.
Okay. You have a video of this incident?
Yes, ma'am.
From where?
From my surveillance cameras.
Is it set up for me to watch it
Yes, ma'am.
here?
Yes, it is.
Okay, I'm ready. That's your car, sir?
Yes.
Okay, let's see that again.
Notice how the truck is covered?
Okay, so you hit the plaintiff's car hard enough to push it up on the curb.
Speed limit is 30 miles an hour.
I've just asked you a question.
Yes, ma'am.
It looks as if you hit it hard enough to push it up on the curb.
Yes, I did.
But you told me a moment ago, Mr. Gilbert, and you just piped in that the speed limit there is 30 miles an hour. You said you were slowing down for a stop sign.
I said I was approaching a stop sign.
Well, when you're approaching a stop sign, you don't approach a stop sign at 30 miles an hour, especially if it's in a neighborhood that you've been in. But according to you, you drive that neighborhood regularly.
Yep.
However, not at that time. That's what you said.
Yes, ma'am.
So if you are approaching a stop sign, when I approach a stop sign, and if I know there's a stop sign there, I start applying my brakes a little bit before. Now, I do drive with some people who sort of like to play chicky with a stop sign, you know. Maybe the stop sign is going to move. Maybe it's going to become a welcome mat. So they wait until they get right up to it and put their brakes on. But that's not what you told me you did.
No, ma'am.
Okay. So now I'm going to say, if you were going very slowly, sir, approaching a stop sign, you wouldn't have hit his car with such force that you push him up on the curb. Okay. Your defense is to this action, as I said, that he was parked and he had this car that was covered and it was parked facing the wrong direction, which is totally irrelevant as to was facing the wrong
according to
direction.
Texas state
It
law.
was on. It's covered over, so you don't know which direction it was facing in. Certainly, the light wasn't on it. If you're
I've passed this.
I didn't ask you for anything. You weren't there.
Yes, ma'am.
You weren't there.
Yes, ma'am, but
She lives in the neighborhood. She drives by it every day.
Just a second. What do I need that for? I have a video.
Okay.
I have a
Can
video.
you see the stop sign in the video? No. You have no idea how
just,
close I was.
You just told me you were approaching a stop sign.
Yeah,
Would
there
you
is
read
a
that
stop
back to
sign.
me?
There is a stop sign.
Would you read that back to me? I was approaching a stop sign. Does he say I slowed down? I was approaching a stop sign. I don't remember.
It's about.
I didn't say.
If you,
I did not.
Now
say,
you can leave.
I did not say I was slowing down.
Now you can leave.
I did not say I was slowing down. I said I was approaching a stop sign.
Okay, that's what I thought. But that's why we have Whitney.
He says he was approaching a stop sign at an intersection by the plaintiff's house, and I can see either a reflection or what I see lights headed in my direction, so I swerve.
Now I would like to see that video again one more time. I would like to see if I see something coming towards you. Actually, I don't see another vehicle coming towards you. Is that a truck parked there?
It's a food truck behind it. It's like catty corner to his vehicle. There's a food trailer there that had all of the light, like right.
A food truck on the other side of the street.
Yes, ma'am.
A food truck that you could see, but that's parked.
Well, I assume since there was no actual lights coming, I assume maybe that's what light reflected off of.
You don't assume anything. All you know is you saw something that made you swerve.
Yes, ma'am.
Whether it was there or not there. So am I getting the fact that your total defense is based on the fact that his car shouldn't have been parked there?
Yes, ma'am. Or covered.
Yeah, well, but that's a finable offense, Mr. Gilbert. That's a finable offense.
If it doesn't cause an accident.
No, I don't think it caused the accident. You caused the accident.
How did
you
I cause
caused the accident. This is an inert object.
According to my HOA guidelines, that vehicle is supposed to be in his garage. According to Texas state law, it's not supposed to be on the road.
And I'm going to tell you, I absolutely agree with you that that's a finable offense if his car is parked.
So
you're trying to interrupt me.
Okay.
That it's a finable offense. The question is his car being parked illegally the proximate cause of this accident? That's the question. Would that be a fair?
It is.
I didn't ask you a question unless you went to law school.
Huh? No, ma'am,
unless you went to law school. Am I in the realm? You're closer than that, was Palsgraf versus Long Island Railroad. His car may have been parked in the wrong spot. Yeah. If you had somebody that left a baby carriage with a baby on the street, which is certainly against the law and would be a neglectful act on the part of the parent, and if you happen to swerve up to avoid something and hit that baby carriage, you can't say that baby carriage is the cause of the accident.
No,
you're the cause of the accident.
No, the owner of the baby carriage is.
No, you are.
No, they are.
So
how am I responsible for their baby carriage?
Because your car is moving, sir, and if you're approaching a stop sign, you're not supposed to be going.
If the vehicle wasn't covered, you could see the reflectors that are on it. That's what they're there for.
Reflectors on what?
Reflectors on the truck that's covered. They have headlights, turn signals, everything that's reflective that you could see. There was no reflectors or signals for me to see to know it was there.
You would have hit it whether it was covered or not.
Horse.
Very good. May I please see the...
That's horse. I wouldn't have hit it could I seen it.
Kevin, I want to see what he's got as far as work for the car. Okay, so this is clearly a project car, sir.
Yes, ma'am.
Yeah, it's people. It don't run.
Get him out of here.
Let's go.
He's done. He's done.
Okay.
Thank you, Lord.
Oh, that makes my life so much easier.
And later today.
You wanted to go. There was no reason why you couldn't. That's why you drive a motorcycle, because you can get into tight places and you can go. But you look like an intelligent young woman.
Thank you, Your Honor.
Don't take chances. That was a chance. It could have been a lot worse.
Bobby Gonzalez claims his neighbor, John Gilbert, hit his classic pickup truck. John is countersuing for car damage and harassment.
By the way, both the defendant and his wife have a counterclaim. Their counterclaim is for damages to their car and for harassment. Well, since neither one of them can keep control of themselves, the counterclaim is dismissed. I'm looking at this truck, Mr. Gonzalez. When did you purchase it, sir, and from whom?
In October of last year. I purchased it online.
Do you have the bill of sale from when you purchased it?
I don't have the bill of sale, but on the paperwork, I have the post on Facebook and how much I paid for it. It was for $8,000.
Okay.
I also have an appraisal on there as well.
I see the appraisal, but I don't have what it's going to take to fix the spot where he damaged the car. He damaged the car in this whole side end.
Yes.
I mean, he's not going to give you a classic car.
Well, I know.
That's not going to happen.
I know. I know
Okay.
that.
That's not going to happen. And certainly, you do understand that I'm not awarding you anything close, even though they're two obnoxious people, anything close to $10,000. You do understand that, Mr. Gonzalez. You're going to have to get this car fixed right now. I'm looking. Where is a invoice for either the work you had done or an estimate to fix that part of the car that he injured?
I cannot give that to you because
Well, then I don't have it,
the
so.
vehicle is a classic. It's very hard to find that type of vehicle.
Well, then what you're asking me is to guess, sir.
Well, I can give you the rates as far as how much I'm
You
gonna have.
can't give me anything.
Okay.
You have to take the car in to somebody who deals with classic cars. So this is a 70-year-old truck, and it's certainly beat up. You had it covered for a long time. It shouldn't have been on the street. You do know that. And I assume that since it's not driven, you didn't have it insured.
Well, I took it out for Halloween, just for the kids.
Well, I mean, where do you suggest that I conjure up a figure of $10,000 when you have a car that's a year old that has never been driven, that you take out and it's a Halloween ornament? So let me explain this to you. I have to guess at a figure. I would be prepared to award you $2,000 to fix your car because I did see that it had to be damaged as a result of the damage to the defendant's car. If you feel as if you would fare better in your local small claims court where this case came from, because I have dismissed their counterclaim, I will dismiss your case without prejudice and you can take it back to the lower court. Take your choice.
I'll go ahead and take it from you. I know I'm not going to get anything from them.
Very good. Judgment for the plaintiff in the amount of $2,000. Counterclaims dismissed. Fix your car. Thank you.
This court is adjourned. Well, I didn't agree on the price, but with them kind of people, I'm not going to get my money back. It's time to get it repaired.
I think you have to be a certain kind of person to not take any accountability when you hit a stationary object. I'll admit, I think that it was probably a 90%, 10% split, 10% plaintiff's fault for parking on the street. I looked up the section code in Texas and did find that if you leave a car longer than 5 days on the street, you're in violation of a code. But like you tried to explain to the very hot-headed defendant, that's a finable offense. That doesn't mean you can ram into it with your vehicle and not be at fault. I just don't know how you take zero accountability after hitting a stationary object.
I don't know either, but that's, I think, a problem with a country that's grown up in the last 50 years, that it's never your fault.
Yep.
It's always somebody else. It's the state's fault. It's the city's fault. It's somebody else's fault. And it's sad because I know that there was lots of acrimony between the two of them without it. But they were hotheads. This is the first time you ever saw me send somebody out.
A long time.
Yeah,
long time since I've seen it. Yeah. But when they're clearly not getting the message and they're being hostile, that's not the proper way to come to court.
No.
Especially when you're in the wrong.
All right, but they have to live near each other. I hope that they sort of get it together.
Just keep your fingers crossed.
Yeah.
Case number 3050, Cockrell versus McMurray. All parties, please step forward.
Justin Cockrell is suing his friend, James McMurray III, for damage after a golf cart hit his car.
Mr. Cockrell, it is your claim that owing to the defendant's negligence, your car was dented.
Yes, ma'am.
Can I see a picture of the dent on your car?
Yes.
Yeah, that's a serious dent. Okay, let me understand the theory of your case. Mr. McMurray is a friend of yours. I assume you were there as well that day?
Yes, ma'am.
You were all having a pleasant afternoon, having a couple of drinks. Were you watching a sporting event?
We were watching golf.
At whose house were you watching it?
Bubba's house.
Your house?
Yes, ma'am.
How many people had golf carts?
2. I drove my car over there. Everybody else lives in that neighborhood, so they'll drive their golf carts.
And Mr. McMurray, what time did you get to the event?
I got there around 2:30 that afternoon.
And did you bring your golf cart?
I sure did.
You drove your golf cart. On what date was this?
May 21st.
So let me see if I've got the alleged facts right. You wanted to leave at some point. You went outside and found that somebody's golf cart was blocking your golf cart.
That's correct, Your Honor.
in the driveway.
Yes, that is correct.
The keys, I assume, were in the golf cart.
That's correct, Your Honor.
The one that was blocking your golf cart. So you moved that golf cart in order to get your car out.
That's correct.
Mr. Cockrow says that when you moved that golf cart, you moved it and left it negligently. So that golf cart rolled down the driveway and hit his car, causing this damage.
Justin Cockrell claims his friend, James McMurray III, owes for car damage after a golf cart rolled into his vehicle.
Is that the theory of your case?
That's correct, yes, ma'am. The golf carts were actually in the garage. I had parked parallel to the garage. So when the cart rolled, it rolled out of the garage and into the side of my car.
Okay. And you, Mr. McMurray, don't deny the fact that you moved somebody else's golf cart.
That's correct.
And you don't deny that that golf cart that you moved caused the damage to his car.
When I got back to the scene, the cart had hit the car.
So those are acknowledged facts. You moved the golf cart. As far as we know, you were the last person that touched that golf cart. That golf cart caused this damage, and he wants you to be responsible. So now, with those agreed facts, which really makes my life so much easier, I want you to tell me why it's not your fault.
Your Honor, when I moved the golf cart, it was blocking my cart. So I moved it to the left of mine. So when I put the brake on the golf cart and walked behind the golf cart to get back to my cart that was right next to it, and I backed up, took my time, making sure I didn't hit the car in my golf cart, I turn around and I head to my house.
About what time was that?
I'd probably been there 45 minutes, so 3:15.
And you went home to do what?
I went to go home to take care of my dog.
What did you have to do to take care of your dog?
I needed to let him outside to use the restroom.
Did you?
Yes, ma'am.
And then what did you do? Then you came back to the house?
Then I came back
to the house?
Yes.
So would you say you were gone 10 minutes?
Yes.
So now you're gone 10 minutes. Just let the dog out. Now you're gone 10 minutes and you come out and you find that the golf cart that you moved, without anybody's permission, by the way, you didn't ask the owner of that golf
No,
cart
I did
if you
not.
could touch it.
The keys were in it.
Well, if the keys are in a car, sir, and you pull up in front of the Piggly Wiggly, and the keys are in a car, but it doesn't belong to you, but the car is sitting right where you want to put your car to put your groceries in, and just because the keys are in the car doesn't mean you can drive it, right?
Right.
So without permission, you got into somebody else's golf cart and moved it. And within 10 minutes, his car is damaged.
That's correct.
So give me a theory, sir, of what happened that you're not responsible for.
Like I said earlier, Judge, I moved the cart, parked it, and I walked behind that cart. If this cart is what they're alleging rolled back on its own, then wouldn't it have hit me when I walked behind it, getting into my cart?
Maybe it needed a nudge from the wind. Maybe it needed something else. But that's not the kind of intervening act, sir, that gets you off the hook.
Well,
doesn't get you off the hook.
Okay.
I'm going to give you an example, my favorite example. Many years ago, I tried a case that changed my life to a minute degree forever. You go grocery shopping, you go to big stores, and they always have a place where you put the grocery cart after you finish loading your car, right? Put them here. So this particular case was about a woman who went shopping and she had a big load of groceries and she unloaded the groceries in her car and then do what some irresponsible people do. They just leave the cart there. Cart can roll, cart, could be touched, whatever. And the cart rolled into another car and caused damage. The defendant's defense to that case wasn't her, it was wind, which is an act of God. Wind came and blew the shopping cart into the plaintiff's car. Well, the wind isn't an intervening act, because if the shopping cart had been put into its place, wind, rain, frogs, hail, nothing would have happened to the plaintiff's car. We understand each other?
We do.
That's actually not the punchline of this story, because after all, we're just dealing with a dented car here. After that case aired, because I was doing it in the television courtroom, I was shopping in Publix in Florida, and I unloaded my groceries in the trunk of my car and was going to leave the shopping cart there. And 3 women got out of a car together who had clearly seen that episode and stood there with their arms crossed, waiting to see if I was going to put the shopping cart back where it belonged. So when I say that case changed my life forever, I can't go grocery shopping anymore unless, I don't care where it is, it could be 20 blocks away, but that shopping cart goes where it's supposed to be because somebody's around who's going to take my picture, leaving that cart around, and it's going to humiliate me. So what I'm saying to you is, it's your fault.
It wasn't my golf cart. It wasn't my house.
It wasn't. It was just like, it wasn't your golf cart, which means you shouldn't have touched it. Which means if you wanted to go home and let your dog out, which you probably should have done a half hour before, then you go inside and say, because you know all these people, whose golf cart is that? It's blocking me in. Can you move it? That's easy. You would do that with a car. You just took it upon yourself to go to touch somebody else's property, and within a millisecond, because nobody else came out and touched that car, you were the last person who touched that golf cart. You were. It caused this damage. You know, don't make excuses. Accept responsibility. Shouldn't have done it, whether you forgot to put the brake on it or not, because I've driven golf carts. We have them around, and sometimes I forget. It says turn it on, and then you hit the brake, and there are 2 brakes. So I never park it like this. If anything, I park it like this against a tree, so it can't go anyplace. It's your fault.
Well, that brings up another...
It's your fault. May I have the estimate to fix your car,
Yes,
please? What year car is this BMW?
It's 2011.
Judge, can I ask you a question?
No, I don't answer questions. That's one of the delights of this job. I ask questions. I don't answer questions. Nice. 1482, judgment for the plaintiff. We're done. Thank you.
This court is adjourned.
Your contract said you would perform for 3 hours. You left.
After being threatened by him and several of his drunk friends, yeah, we didn't want to play after that.
He's having a huge party. You didn't perform.
I rolled up to about 10 people. 5 of them were toddlers. There was nobody there.
I don't care if there were 2 toads and a lizard on the ranch.
This is Judy Justice. Singer Sophia Rolando is suing her former client, Ryan Birdwell, for breach of contract, car damages, and tow.
Judge, case 3176, Rolando versus Birdwell.
Thank you.
You're welcome.
Mr. Birdwell, I'm going to start with you, sir. The case is relatively simple. The plaintiff says she was hired to perform at a function that you were putting on and that you didn't pay her. And the agreed price was $3,000. That's your claim. That's your claim.
Yes.
What do you hesitate for?
I hesitate because the price of the event was $1,500, but I'm also suing for damages and the tow truck that accrued moments after the incident.
Were you born here in California?
I was born in Wisconsin.
How long have you lived in California?
Almost my whole life, 25 years.
Well, counts for some of your nonsense. What kind of function was this, sir, and where was it being held?
It was being held in Boulevard, California, and the function was, it's an annual spring party we do up at a ranch we have called the Shreddy Ranch, and we hired her to perform.
No.
Sorry.
Don't get ahead of yourself.
Sorry about that.
I asked you what kind of function it was.
It was an
annual function. And what was the date of the function?
I believe April 12th. I don't know. I'm not clear on the dates.
Well, find out. That's what you're supposed to know. You're a party to this action.
April 15th.
Of 2023?
Yes, ma'am.
How many people were you having at the event?
About 150 people.
What time did the event start?
The event it's a 3-day event. It starts from Friday to Sunday.
And what day was the 15th of April?
Saturday.
Saturday night, so right in the middle. Do you serve food?
Yes, we have it catered on Saturday.
When you say we, who's we?
Well, me. I had the party catered.
Okay. Who is the host of this party?
I am.
You are. You paid for it?
Yes.
Okay, and you do this every year?
Every year. We actually just got done with our 3rd annual party just last weekend.
I have enough from you. Now, Ms. Rolando.
Yes, Your Honor.
According to your complaint, the defendant saw you perform sometime in March.
Yes, March 18th, 2023, at the Ritz-Carlton Laguna Niguel.
And you're a singer?
Yes, Your Honor.
And I want you to tell me the exact conversation that you had with the defendant Because he came up to you after you sang, and he approached you about performing a month later
Yes.
at his event.
Yes.
I want you to tell me exactly what he said to you and exactly what you said to him.
Over text or the in-person conversation? When
Well,
we
he
first
didn't
met?
speak to you in text the first time he spoke to you. He came back to see you.
Okay, my recollection is that he came up to me and told me that it was going to be his wife's 40th birthday party.
Just a sec. Did he say, I liked your singing?
Well, yes.
I want you to tell me exactly what he said to you.
All right, he said, I loved your performance. I'm throwing a big birthday bash from the 14th, 15th, and 16th of April. I would love to have you come on the 15th. It's going to be the biggest day with hundreds of people, famous people, drones and cameras, and you're so good. That's the day that I would like you there.
Great. So you understood that it was a big event.
I did understand that.
Great. And you said, fine. He must have said, how much do you charge?
Actually, there was a little bit of discussion in between that time because on the 15th, I was already scheduled to play a festival with my band on April 15th, 2023 at Kushstock Festival in Adelanto, California. That's very far from where Mr. Birdwell lives. And so I told him I have text evidence, before we ever signed any contract, I told him, I will not be there. I'm coming late. I'm probably leaving this festival by 5 o'clock. I will be there before 10. And you will get your 3 hours.
I would like to see that in a text.
Yes, ma'am.
Because this is what the case is about.
I have those text messages.
The party started at 7.
Yeah, she was supposed to perform at 7.
Party started at 7. He says you were supposed to be there from 7 to 10. When you got there, and that's a matter of dispute, it was well past 7. Another act was performing, an act that Mr. Birdwell had commissioned to perform from 10 to 1. So there would be continuous entertainment. When you got there, you found another act performing, and Mr. Birdwell said, well, you can perform stop playing, because you're not listening to me if you're playing.
I'm sorry.
Got to pay attention.
Yes.
Mr. Birdwell said, well, I already have this other act because you weren't here. You can perform from 10 to 1, and you said no, and you left. That's the case, right? That's the case.
Yes, that's the case.
So far, you're not losing. If you're not losing, I keep my mouth shut. So far.
Yes, Your Honor.
That's the case. Okay. Now, I would like to see first a contract.
Yes.
Do we have one?
I have one.
May I see it, please?
And in the contract, she never signed the contract.
Shh. You see, you always add something.
Sorry.
You always add something. Okay, so you contracted for $1,500.
Yes, Your Honor.
That is correct. And this says description 3 hours.
Yes. And I did.
Shh. Okay. And he sent this to you on March 21st.
Yes.
He sent it to you on March 21st. Well, it's dated March 21st. You didn't sign it.
Okay.
Singer Sophia Rolando claims her former client, Ryan Birdwell, breached their performance contract after Ryan and his friends threatened her during his party.
Now, you didn't sign it.
I did sign it. I'm not sure why he received an unsigned copy.
May I see your signed copy?
Yes, you may. Oh, thank you.
Well, now I have a signed copy with signatures on it.
Yes.
And this says 3 hours, doesn't specify the time.
Yes.
Is that right?
That was purposeful. Yes.
That was purposeful.
Yes.
Okay, so you were commissioned to sing for 3 hours, according to you, unspecified hours. Just a second. That's what you're telling me.
Yes.
Great. Now I'll see the text messages back and forth where you discuss time.
Okay.
Not okay. First text message, second text message with the dates.
Yes. So
Oh, don't say anything I can read.
Okay.
He says on March 19th, we would love to have you there to start playing at 7 p.m. on Saturday, 4:15. That's the last thing that this is here.
There's more.
That's March 19th. Next. And the next one that you hand me is April 15th. So between March 19th, you signed a contract for 3 hours, and the next communication that I have is April 13th. Excited for this weekend. Can't believe it's already here. Going to be awesome. Hey, Ryan, I just want to make sure there is any dress code, and my pianists know where whatever you want, people are going to be wearing whatever is on the ranch. Super fun. I'm coming from a weekend festival. I'm playing too, so I'll be wearing what I'll be playing there. Then I have the Saturday, April 15th at 10 of 12 in the morning. Hey, can you send me your address? Send that as soon as you can. Thanks. Oh, I actually got it. Sorry. All good. See you soon, and we'll hang out. We hope to be there for the Downbeat 7, but we're pretty far away at this fest, but we're about to play and we'll be out of here by 4. That's what you say to him, and you say that to him on April 15th. That's the first time, unless you have early...
I actually...
Well, I'm just reading this.
I'm so sorry.
I'm just reading this. You say, we hope to be there for Downbeat at 7, which is when you were supposed to be there. So let's make that clear. Let's make that clear. You knew you were supposed to be there at 7 because you say, we hope to be there for... You mean you didn't write this?
I'm sorry, I did write that, but...
Pay attention.
Yes.
You wrote,
yes, Your Honor.
On the day of the event, we hope to be there for the Downbeat at 7, but we're pretty far away from you at this fest we're about to play, but we'll be out of here by 4. We're gonna be there later than 7, but you'll have your 3 hours either way, and we'll keep you updated. 4:35 in the afternoon. And then on the 17th, I'm not interested. All right, you have things that you want me to read
I do.
before this.
Yes,
okay, but on
I do.
Date of the event, 2 days before the event, you say, we'll be there at 7. Now, let me see the other thing.
Did not say that.
Don't speak. Just give it to me. Nonsense. I don't want to see anything that happened before March 21st.
But that's kind of the most important part for me, because I told him before we ever signed the contract, I will not be there by 7 p.m.
Just
I
a
told
second.
him.
Hey. Man, you're supposed to be a professional. He's having a huge party.
That's why I offered him a different date.
Don't speak.
I'm sorry.
Don't speak. You're suing him. You didn't perform. You're suing him. You didn't perform. You're a professional. He's have 150 people there. And you said, we're going to be late. We're leaving at 4, but we're going to be there after 7. Now, you're the professional. What did you expect to happen with 150 people there and the entertainment wasn't there? What did you expect to happen, Miss Professional?
Your Honor.
No, I'm asking you a question. Did you expect them to just go on with the party?
First of all, I expected...
That's what you expected.
I expected the party that I was promised. I rolled up to about 10 people. 5 of them were toddlers. There were no cameras, no drones. There was nobody there. I am a professional.
Just a second. Was there another group playing when you arrived? You swore to that.
Yes, and when I arrived...
You arrived, there was another group playing.
Yes.
Is that correct?
Yes, which he...
What's up? There was another group playing. I don't care if there were 2 toads and a lizard on the ranch. There was another group playing for the 2 toads and a lizard, and the defendant and his wife. There was another group playing.
Yes.
What time did you get yourself there? Be very, very careful. There's a way to track it. What time did you get yourself there?
I was in the...
That's a time
okay,
that I was in.
8:40 p.m.
What?
Between 8:30 and 8:40 p.m.
Okay, so between 8:30 and 8:40, that's not 7:15.
That's because
don't speak. That's not 8:15.
Have something important to say.
That's not 7:15.
Yes, I'm aware of that.
Okay.
I promised him I would not be there by 7 before we ever signed a contract, which is why I offered him 4:14, because I was completely free that day. I told him in text, March 20th.
You think you're the only singer? You think you're the only singer in California? No. Just a second. You think matter? I mean, I don't know where the headspace is here. They raise a bunch of babies here, and maybe if you're in the entertainment business, you're a double baby.
Singer Sophia Rolando has accused her former clients, Ryan Birdwell, of breaching their contracts after he threatened her for refusing to sing at a later time.
Somebody hires you for a function. You say, I'm totally free.
I told him I was busy that day.
Don't speak. I'm totally free on the 14th. Well, he didn't want you for the 14th. He wanted you on the 15th. A professional would say, I'm far away on the 15th.
I did tell him that.
Hey, don't speak. I'm far away on the 15th. I don't think I can do the 15th.
Exactly what I said.
I don't think I can do the 15th. So maybe we'll do it next year. Maybe we'll do it at another time. I have one other question. When you arrived at 8:45 and you saw the other group singing, because from what I gather, put your paper down, from what I gather, the group that was supposed to perform at 10 was there early.
Yes, Your Honor.
Because you had booked from 7 to 10 and then someone after, so there'd be continuous entertainment.
Exactly.
Now, when you arrived there, be very careful with your answer. Did the defendant say you can play from 10 to 1? Be very careful with your answer. Did the defendant say...
He actually had no idea who I was and said, I thought you canceled. That's what he said. He said, I thought you canceled. That's what he said.
I want you to answer my question. Did the defendant say to you, you can sing with your band from 10 to 1? Be very careful what you say to me. Did he say you can perform from 10 to 1? That's either a yes or a no. Your silence, I would assume that he offered you 10 to 1.
After many threats, yes,
Just a
he
second.
offered that.
He offered you. What's wrong with you?
Sorry.
What is wrong with you? Are you? Is this your wife who turned 40?
Yes, sorry. I have a text
My
where
sympathies.
she admitted that I asked her to play. Sorry, Your Honor.
I know that
Just
you
a
did.
second.
I haven't been able to say one thing of importance.
Just a second. Sir.
Sorry.
Is he always like this?
Yes.
Is he always like this? Okay. You must have other attributes that I don't see. Do you understand? Your contract said you would perform for 3 hours. If he wants you to perform from 10 to 1, you perform from 10 to 1. You left.
After being threatened by him and several of his drunk friends, and they were belligerent and threatening us like this, every time I said the word contract, he got even more pissed off and threatening us. Yeah, we didn't want to play after that. We also had work in the morning, and he knew I wouldn't arrive until after 8. We had a phone call before I ever signed this contract because I am a professional, and I knew I would never make it at 7 p.m. I told him before the phone call, I will come and play before 10 p.m. Me arriving there and having to wait an hour and a half is him breaching our contract.
Oh, you think so?
Yes, I know so.
No, you don't know so, madam. You don't know. So your contract is very, very clear. You can't have it both ways. You can't use, and I'm going to tell you, it's a nuanced part of contract. This is your contract. You gave me the signed contract. Any parole evidence outside parole, not written in the same form as this contract, which is signed on both sides, is inadmissible when it's a contract. This contract said you will sing for 3 hours. You didn't sing for 3 hours.
I felt very threatened, so I left.
Well, that's too bad. I'm sorry. That's why I'm talking about people raised in California. They feel threatened. This is my space.
He was a drunk.
No,
he was a drunk.
My space.
He was a drunk, and his friends were drunks as well.
You're interfering with my personal space. You signed
They were
a
drunk
contract.
and belligerent.
Listen,
and hovering over us.
Madam, you do not appear to be a shrinking violet to me. Most people are intimidated by me. You are not, which suggests to me that you weren't intimidated by somebody. Well, then maybe a little therapy will help. You signed the contract, 3 hours. You didn't perform. He gave you the opportunity to perform from 10 to 1. Your case is dismissed. Grow up.
This court is adjourned. 3007, Lacey versus Mayo. All parties, please step forward.
Courtney Lacey is suing her former friend, Marcus Mayo, for business products, lost wages, and harassment.
Right, Ms. Lacey, there's a whole story here that really doesn't necessarily impact on the bare bones facts of this case. The bare bones facts are you met the defendant on TikTok.
Correct.
And you were in the beard business. That is, you made products for men, for their beard.
Yes, ma'am.
I assume that jar that's there for show and tell is one of them. You threw her product away. There were other things that you could have done with it. You sure you threw it away?
I did.
You did? Why? You couldn't use it? You didn't like it for your beard?
It meant nothing to me after that. I was just looking at it, made me mad.
Courtney Lacey claims her former friend, Marcus Mayo, threw away her beard products without permission. Marcus is countersuing for rental car charges and lost work.
Now, the defendant traveled to where you live from what state to what state?
Connecticut to Ohio.
In order to help you at a fair to sell your product.
Yes, ma'am.
When? What month and year?
My event date was April 1st of 2023, and he did come in 2 days.
So around April of 2023 is when you went to the fair, and there was a fair. I don't know whether you sold products or not, but you went with her.
Yes, ma'am.
Was there a business arrangement? Were you supposed to get any financial remuneration, or were you just meeting this person in the flesh that you had met on TikTok?
Nothing was talked about. We just showed up and winged it.
Okay. And then whatever happened, you were leaving and going back to Connecticut.
Yeah.
And when you left, you took some product with you.
I was given the product.
But you took some with you.
Yes.
I didn't say you stole it. You took some product in your car,
Yes,
right?
ma'am. Yes.
Tell me what you took in your car.
It was a couple of cases. I believe what she said was 78 jars of a product.
78 jars of her product.
Mm-hmm.
How many had you sold at the fair?
I sold about 3 at the vendor's event.
You sold 3?
Yes.
I also donated $40.
I don't care. 78 jars is what you took home.
Mm-hmm.
Okay. And what is the retail cost of these 78 jars?
$25 a jar.
And what is your cost? You're in business. To make that jar, what is the jar and the product? How much does it cost?
With everything put together, it cost me roughly around $6, $7. Just depends on what scent I'm using.
So say it costs you $6 a jar. That would be $468. Okay, you're suing him for $3,600, so that's ridiculous. So he took this product, and at some point, you wanted it back.
Yes.
So when did you tell him you wanted it back?
When I seen that he was bashing me on social media once he left, I wasn't aware that he felt some type of way. I asked
Just
him,
tell me what date it was that you wanted it back.
It would have been April 3rd.
And did he tell you that he would send it back if you paid for it?
He did several times.
He did several times say, I'll send it back if you send me.
Yes.
And did you?
He said that he was going to go to the UPS store and overnight it. I told him I did not have overnight money. And then he told me he was going to throw my product away, that he wasn't going to mess with it.
And that was in April. What'd you do with the product, Mr. Mayo?
I held on to it.
No, it's April. That's not a long time ago. How long did you hold on to it?
I held on to it for a week. The following Monday, I'd heard nothing from her. She blocked me on everything. I said I'd give her 2 days to give me a call, let me know what's going on.
Do you have that in messages?
Every message between us that whole morning is right here.
By the way, what were you going to do with these 78 jars?
She wanted me to sell them for her and give her the money. I was under the understanding that I was going to.
Did you say to him, throw it away, I'll report it as stolen property?
After the numerous threats
Just a second.
telling me.
Did you say that to him?
Yes.
Okay. So, sounds that to me, and I've read the papers, and the text messages between you seem to support the idea that he came for a few days, you rented a car.
I rented the Tesla.
How much was the Tesla to rent?
Rented me about $1,400. I have the actual.
Okay. No, I'm not entertaining your counterclaims, sir. Okay. The counterclaim's nonsense. But he rented a car to come to help you. You hadn't actually met him before.
Right.
And when he came, your children were someplace else for the event, for the weekend, or you thought for a few days, and he was going to stay with you on your sofa. That's what you said.
Only for the event.
Well, he wouldn't have driven, I don't know how many states away, and rented a car to come for 1 day. That sounds ridiculous. And you actually acknowledge that you weren't expecting your children to come home, but your children were coming home, and you felt uncomfortable about him being in the house when your children were home, so you asked him to leave. That you acknowledge.
Right.
Okay. And so he left. I don't know whether he left during the course of an argument, but somehow he took these jars of product worth $460, and he didn't take them without your permission. He took them with your permission.
Right, we had an agreement.
That was?
That he was going to take some back. He had some barber friends and friends that was interested in buying.
Right.
And he asked if he could have a box of each scent.
Okay. And he took 78 boxes back, which are worth $468. That's your cost.
That's the price it cost for me to
Yeah, he's not paying you. He's not paying you for what you retail it for. You had a disagreement. He offered to send it back if you paid for it. He held on to it for a week. Should he have held on to it longer? I don't know. That is a sort of subjective thing. I can't say you should hold on to it for a month. You should have sent it to her COD if she didn't want to pick it up. She didn't have to pick it up, but I don't know where you send things COD anymore. I don't think that they do that anymore. Anyway, your whole loss is maybe $400 in product and jar.
But he took the jars to sell them for me to his friends. I
don't
offered him
care.
permission. And
I
he
don't
didn't want
care. Seems to me that you both made some bad choices. It wasn't explained to him, and I don't know what he was thinking, nor do I want to know what he was thinking. You know, to drive for a day and a half to come to your house, not knowing who you are. He went to the event. He was helpful at the event, and then you told him that you had to leave, go to a hotel. That's what you said.
We didn't talk about the plans after the event. That's where
Well,
the
then you should have.
miscommunication came.
Actually, you should have.
Right, and I took accountability for that.
$468. You threw her product away. There were other things that you could have done with it. You sure you threw it away?
I did.
You did. Why? You couldn't use it? You didn't like it for your beard?
It meant nothing to me after that. I was just looking at it made me mad.
Okay, good. $468. Judgment for the plaintiff. We're done. Thank you.
This court is adjourned. Case 2137, Weiss versus Light. All parties, please step forward.
Caitlin Weiss is suing her ex-boyfriend, Cody Light, for unpaid loans.
Ms. Weiss, the defendant was a boyfriend of yours for a period of time.
Correct.
And you allege a couple of loans. One from a year and a half ago, the balance of a $200 loan, he paid you back $100.
Yes.
Quite frankly, I'm not interested in what happened a year and a half ago. What you say is, I need time to catch up.
It was a verbal conversation.
Well, what's in writing is you saying to her, I can make payments to you. But the thing that you don't have in writing is where she forgave the loan. Is that right?
Caitlin Weiss claims her ex-boyfriend, Cody Light, is refusing to pay back loans she gave him during their relationship.
Okay, in March of this year, you allege that you gave him money. He was still your boyfriend in March of this year, is that right?
Yes.
Is that correct?
That is correct.
And in March of this year, he had gotten a car. What kind of car did you get?
It was a Buick Regal.
What year?
A 2004, I believe.
Where did you get it from?
I got it from a private seller.
How much did you pay for it?
$850.
Needed fixing.
Yes.
And you didn't have money for parts.
I did for the first round of parts.
But you didn't for the second?
After the first ones failed, I did not.
And how much did you need for parts?
That I don't remember.
Who bought them?
Miss Weiss did.
Did you buy them on a credit card?
I believe so, yes.
And you have no idea what you paid for those parts?
I don't remember.
But that would be in March of 2022.
It would have been in April.
Did you pay for the parts by credit card?
Yes, I paid between Cash App transactions that were transferred to Mr. Light through Cash App, which I have present here.
I'd like to see proof of them. What do they total?
They totaled up to $920.
Does that sound about right, Mr. Lippy?
That's about right.
Okay. And tell me about the discussion that you had with her when she paid for these parts.
There was a discussion of how I was going to pay her back.
And what did you tell her?
I did agree at that time.
And then what happened?
There were then later discussions as we were still in a relationship and I was in financial troubles that she told me not to worry about it.
This $920 was a loan in April of 2022. That's what you say. It was in April, not March.
Correct.
And then you say at some point she forgave that loan.
Right.
Tell me when that happened.
Shortly after the car got back together, which would have been in May. I was financially struggling.
Well, you weren't living together at the time?
No, she would periodically come over and
yeah, but you weren't living together at the time. So how would she find out that you were in financial trouble?
I mean, we were at that state in our relationship where she knew basically my financials all the time.
When did the two of you break up?
I believe that was in June.
So shortly after you say she forgave the loan.
That is correct.
Did you ever forgive this $920 loan?
No, I did not. Brennan Black was there the day that I had confronted Cody at a car meet and had offered him a short little payment of $790 where Cody said he would do it in payments.
Just a minute. You broke up in June.
Correct.
He says that you had a conversation before that, sometime in May, where you knew he was in financial difficulty. Did you ever have that conversation with him?
No, that is incorrect. I do have statements here to prove it as well.
I'd like to see them. So then you said he owed you $970. He had been giving you some money?
Yes, he had been giving me a
It
little
says, so that puts you at $670, okay? That's what you wrote.
Correct. He had been giving me money periodically throughout the beginning of the car parts.
Okay, but it says, so that puts you at $670, okay?
Yes, there's more transactions on the Cash Apps as well.
Oh, after that?
Yes, correct. Sorry.
No, sir. What you say is I need time to catch up. There's no forgiving here unless you have some.
It was a verbal conversation.
Well, what's in writing?
Right.
What's in writing is you saying to her, I need some time to catch up. I can make payments to you. All of that is in writing. But the thing that you don't have in writing is where she gave the loan. Is that right? Yeah. $920. Judgment for the plaintiff. We're done here. Thank you.
This court is adjourned.
It is what it is.
I think it was fair. Mr. Lake did owe me money, and he got what he deserved.
Yes, she lent me the money, but at the same time, she was helping me out in a relationship, and she knew I was struggling.
He said he was going to pay me back and never followed through even after that.
There were discussions about her telling me not to worry about it.
Not to trust so much.
I'm never going to do it again.
Oh, that's going to be a contract.
She was very prepared.
Oh, she was to the point, knew exactly what she needed.
And she had all of her evidence. Yep. All
just the way we like it.
All lined up. It's unfortunate when a loan becomes a gift and a gift then becomes a loan when the romance is over. These writings are always so helpful, and these text messages really are making my life much easier.
And one thing that I mention a lot is with Cash App or Venmo, always state if you're paying someone money, don't just send the money, put in the subject line. They have a subject line on those for a reason, for this car part, for this tow, for this XYZ, the other. So I always, when using Venmo or Cash App or something like that, in an online transfer system, I'll send the money, and then in the transaction, you can put whatever you want in the memo line of Venmo. So housekeeping for me, I'll pay through that. Other things, I list housekeeping for, and I put the date and the hours. So I at least have a record of who I'm paying electronically.
If you buy food,
or if I give someone money for dinner for half my meal, I say for my dinner on XYZ date.
And then you can get a printout.
Organized. Exactly.
And then you can, like a bank account?
Yep.
Interesting. I didn't know that.
It just keeps it organized.
Avril Matthews is suing her former friend, Unati Mia, for medical bills after Unati damaged her teeth.
Court come to order. All rise.
Have a seat, please.
Hello, Judge.
Hello, Kevin.
Case 3057, Matthews versus Mia.
Thank you.
You're welcome.
Miss Matthews, how long do you know the defendant?
A few months, Your Honor.
Where did you meet her?
We met at a gathering, like through mutual friends.
And when did you meet her?
I would say probably the beginning of last year.
Give me a month and the year.
Probably like June. Maybe like in the
June
in summer,
is a
like
question.
Last year.
I don't know when you met. The beginning of last year would be a January, not a June.
Okay.
That would be the middle of last year.
I would say
the questions are going to get harder, Miss Matthews. Not easier. They're going to get harder.
Okay.
Do you understand?
Yes, Your Honor.
Now, when did you and the defendant meet? Month and year?
May 2022, last year.
And the incident that you reference in your lawsuit against the defendant happened in April of 2023, so approximately a year later.
Yes, that's correct, Your Honor.
Between May of 2022 and April of 2023, about how often did you and the defendant see each other?
I would say probably every other couple of months or every other weekend. Like it would be a regular
Just a
thing.
second. I want to tell you how silly you sound, because Whitney is going to read back what you just said. How often did you see each other?
On a regular
and
basis.
Just a second.
Sorry.
I'm going to tell you what you just said.
I would say probably every other couple of months or every other weekend, like it would be a regular.
Every other couple of months would mean that maybe you saw her 4 times. If you saw her every other weekend, that's a different story. Do you understand? You have to get your story straight before you come here. Do you understand?
Yes.
Story straight. You get it?
Yes.
Okay. Now, this is what the case is about. So now I got my players. Is your claim that on an evening in April. The two of you went out for dinner, ended up in someone's apartment, I think yours. And the two of you were in the bedroom, sitting on the bed, phone rings, and it was your phone?
My phone.
Your phone. And somehow, according to the complaint, the defendant threw the phone at you and broke your teeth in the front. And that's what you're suing her for.
Yes, that's correct, Your Honor.
Okay. So that you don't know when you met her, and you don't know how often you saw her, but that you remember.
Yes.
So let's start with that evening, and then I have a few questions for you. Let's start with the evening of April what?
April 1st, 2023.
Did you meet her at a restaurant, or did you pick her up, or did she pick you up?
So we actually picked her up, and
we actually picked her up. Who's the we?
Me and a friend of mine.
Picked her up?
Yes.
And the three of you went out for dinner?
Yes, that's correct.
Finished dinner at about what time?
After 10, maybe going into 11 o'clock.
And now there are three of you leaving the restaurant at 11 o'clock.
Yes,
Keep
that's
going.
correct. So at the restaurant, we had some dinner and drinks, and we were having a conversation. I think it was like a debate, and we were speaking about something about how, from a woman's perspective and another woman's perspective, how a man would probably react to a certain situation, and we were in a disagreement about something. And then she proceeded to play fight with me, which I thought at the time was
You're talking about at dinner?
Yes, at dinner, at the restaurant, when we all three were there, and we were having a couple of drinks, and she proceeded to get physical with me. So it was play fighting at the time that I thought.
All right, just a second. Play fighting at the restaurant before 11 o'clock. Okay, so now there's play fighting before 11 o'clock, and what do you do when you leave the restaurant?
So we proceeded to go to a nightclub, but during the play fighting, I just want to go into detail that she had bit me.
I don't want to go into detail.
Okay.
Do you understand?
Okay.
I want to get to the case.
Yes, Your Honor.
Now, you went to a nightclub. Did the three of you go to a nightclub?
Yes, Your Honor, we did.
For how long?
Close to 2 hours.
So now we're at 1 a.m.
Yes.
Did you have a good time at the nightclub?
Yes, you could say so. Yes.
I'm just
curious. It was okay.
I'm just curious.
Yes.
Did you dance?
Yes, you could.
Who did you dance with?
We would dancing with each other, probably, we'd sit down and then we'd get up.
Not probably.
Excuse me?
Not probably. I wasn't there.
Yes, we would dance with each other, and then
good.
we would sit down, and then depending on what kind of music would be playing.
So it's now 1 a.m.
And later on, my witness joined us at the nightclub. So we were then 4 at the nightclub together.
Okay. And when did you leave the nightclub? 1 o'clock?
Yes, I would say probably around 1.
Well, that's what you said before.
Yes, I think we were maybe there for a little bit longer because we then went to McDonald's afterwards. And at that time, they were selling breakfast.
What time did you leave?
So I would say much later than that. Now that I'm thinking about it, a little bit later than that. Good. Apologies, Your Honor.
Good. About what time?
I would say right when the nightclub was closing, so probably about 3.
So from 11 to 3, you were at a nightclub drinking and dancing. And then how did you get to McDonald's?
We drove.
Who drove?
My friend of mine that's not here currently.
And from McDonald's, where did you go?
We went to my place, Your Honor.
Did the 4 of you remain there?
Yes, Your Honor, the entire night.
Okay, so they were there and your friend was also there during this incident?
Yes, that's correct, Your Honor.
So now you can tell me about the incident.
Okay, so we got to my place, and after coming from McDonald's, we got out of the car, and she had bit me again.
I want you to listen to me.
Okay.
I want you to get to the incident.
Okay.
We're not here at...
Avril Matthews claims her former friend, Unati Mia, owes for medical bills after she threw her phone at Avril.
So I want you to get to the period of time when you were injured. Who was there in the room and how it happened? Do you get it?
Yes, Your Honor.
Perfect.
So we got into my place, and we were all sitting. We were in the living room, and we were all waiting for each other so that we could all eat together.
What do you mean, all eat together? From where? From McDonald's?
Yes.
So you had brought McDonald's back
Yes, Your Honor.
to your house?
Yes, Your Honor.
Okay.
Yes.
Now move on.
I was in my room and Unati was with me in the room and Haji was out in my living room. And Unati got up and her phone rang or a beep or a text came through from her and she got, I don't know, like aggressive and wanted to get my attention to show me what was on her phone. And at that time, she called my name and I didn't respond to her. And she wanted to get my attention and she threw the phone at me. And I looked and I was like, oh, okay, like, wow. And out of shock, I then got up and I went to the bathroom. And at that time, Haji had witnessed her because Haji was going to the bathroom. So Haji walked in and at that time heard like, Avril, you know, I'm trying to get your attention. And Haji then saw her throw the phone at me.
Don't tell me what she saw.
Okay.
So she got up to go to the bathroom. The defendant's phone rang. Where was the defendant when you say her phone rang?
Well, she got a message.
Just
her phone
a second.
didn't ring. Okay, sorry, Your Honor.
Message, a bing, whatever it was. Where was she?
She was in the bedroom with me, Your Honor.
Bedroom where?
So I was laying on the bed, Your Honor.
You were laying on the bed.
I was laying on the bed.
You were laying on the bed.
Mm-hmm.
Was she on the bed or was she standing?
At the time, she was sitting and then she got up.
She was sitting on the bed.
Yes.
Where was her phone?
Her phone was in her hand, I believe.
Just don't say you believe. I wasn't there.
Okay, yes, her phone
I wasn't
was in,
there.
Her phone was in her hand.
The phone was in her hand.
Yes, Your Honor.
Okay. So she was sitting on the bed. Her phone beeped or rang. It's in her hand. And she got up to a standing position.
Yes.
And she's looking at her phone or she's speaking into her phone?
She was looking at her phone. She wasn't speaking into her phone.
So she's now standing up, looking at her phone and
tried to get my attention.
Just a second. Trying to get your attention is a conclusion.
Mm-hmm.
What did she do?
She called my name and I didn't respond.
And you didn't?
And I think that's when she threw the phone to get my attention. But it was, I would say that it was I don't know what text message she got.
Just a second.
Okay.
And that's how your teeth got injured.
Yes, Your Honor.
Perfect. So we have found the story. Now I just have to read this. Well, you see, your complaint, Miss Matthews, says that the phone was not in her hand. It says her phone beeped. She got up from the bed and grabbed her phone. That's what you said in your complaint.
Okay, so apologies, Your Honor. I think I was just trying to, figure out exactly what happened.
You know, we're not here at some science class, madam. We're in a courtroom. You signed a complaint.
Yes.
You know, I find this whole thing a little bit fishy anyway, and you're just feeding into that with some of your responses to me and some of what's in your complaint, because it all sounds bizarre. So I know I'm missing something. So was the phone, when it beeped, in her hand, or was it in a place where she had to get up and go and get it?
I would say that...
Not I would say. I don't want to know what you would say. I want to know the truth. There aren't different versions of the truth. There's only one version of the truth. So not I would say, think about it. And were you correct when you swore to this complaint that she got up and grabbed the phone? Or were you correct when you testified a moment ago that the phone was in her hand?
I would say that I was correct when I said on the paper that she got up and picked up the phone.
Now I'm going to go back. Where did she pick up the phone from?
I have a dresser in my room.
A what?
I think it was the dresser. I'm not sure,
If you say, listen to me, if you say, I don't know how this happened, it all happened so fast, that's okay. But if you I think I have a dresser, and this is a dresser, so I think the phone was on
I would say that it happened off, I'm just trying to replay the night, but I think that she got up and she took the phone, and that's when she got the text message.
Great. I feel so much more comfortable than when we started. All right, let's get to the bedroom.
All right.
Who was in the bedroom?
It was Avril, and...
Where was she?
She was in the living room.
And can you tell me why you were in the bedroom instead of in the living room?
I can't tell you. We don't know. We were in the living room and then we just went to the bedroom. I really don't.
Okay, go.
Yes. So my phone was actually on her dresser. I had put my phone on the dresser when we came in, on her nightstand dresser in front of her bed. I got the text message. I stood up and I went around her bed and I went to get my phone from the dresser. I stood in front of the bed and she was in front of me, obviously on the bed. And I got a text message from a guy that I was talking to at the time. And I wanted her to see. So I was really excited and I was telling her, oh, he texted me, and I was telling her what he was saying. And she's like, oh, let me see. And then she put her hands out and I, in an underhand position, I passed her the phone.
So you tossed the phone?
I did.
You tossed the phone at
yes,
her?
Your Honor.
And is that when it hit her in the mouth? Okay. Prior to all of these...
Avril Matthews is accusing her former friend, Unati Mia, of throwing her phone at Avril and damaging her teeth.
And then it took us a long time to get there, but clearly this was an accident.
Absolutely.
Accident happens when you're in a car. You don't mean to hit anybody, but you do. Accident happens if you're parking the car. You don't gauge that parallel parking just right. Well, if you're from Brooklyn, you always gauge the parallel parking just right. But it's an accident.
Your Honor.
But when...
Oh, excuse me. Sorry.
When you have an accident, you have to pay for the accident because it's not an on purpose, but it's an accident. So I would like to see, dating back to the week of April 1st, any text messages that you have or emails between the two of you discussing the incident of April 1st.
April 1st.
In the week of the 1st, this is the only...
This doesn't say anything.
That's just the only conversation over text that we had.
Well, this doesn't say anything about the incident that happened.
Yeah,
nothing. Okay, let me see your evidence, Ms. Matthews, about the incident itself. You show me all those pages.
No, it's not any conversation regarding the night of the incident. It's all the conversations that we had regarding after I went to the ER and the bills.
I would like to take a look at those. Okay, well, it's clear, Ms. Maya, that prior to all of these emails, you and the plaintiff had a discussion where it was clear between the two of you that this accident was your fault, because all of these emails discuss with the plaintiff payment. And to summarize what I've just read, she went to the emergency room. She went to a dentist. She got estimates. She was in discomfort. She told you what the proposal was. You said to her, you can get someplace cheaper. She said, I'm not going to do that. You said to her, well, if you're not going to do that, meet me halfway. You know, I make the minimum wage. I can't afford all of these bills, which suggests to me that you understood your culpability, right?
Yes, Your Honor.
And I'm not suggesting, nor was there any indication to me that this was a purposeful assault. It wasn't. It was a stupid accident. You were both probably drunk. I'd like to see all of your medical bills, please, starting with the ER. There's a lot of bills for me to go through.
Yes.
Did you have the work done yet?
I had some work done, and for future, I still have to have one more procedure done on me, Your Honor.
I'd like to take a look at the report from the dentist requiring another procedure.
Okay.
Maybe. But let's see what you had done so far.
Okay, Your Honor. Let me just put it in order.
And you have proof of payment of those bills?
No, I haven't paid any of it, Your Honor.
None of it? You mean the dentist worked for nothing?
I have the proof for the consultations that I've paid. So I paid for the consultation.
I want to see proof of payment of how much you paid. So your initial visit at the ER was $985.
Yes.
And it is for a tooth. That's what it says. A tooth.
So they had placed... Okay.
Just telling you what it says. Okay. So a lot of this work has yet to be done.
Yes, Your Honor.
Okay. And
But
in order to have it done, they want to be paid.
Yes, Your Honor.
Okay.
But the 4,600.
I didn't ask you a question. You understand, Ms. Meyer, that I believe that this was an accident.
Yes, ma'am.
I don't believe that it was an accident.
I don't care what you believe, and I didn't pose a question to you. You understand that I believe that this was an accident.
Yes, ma'am.
It was an accident, however, that you caused. And when you cause an accident and someone is injured, you have to pay for it. And she has to have work done. She's a young woman, and she shouldn't have to have this kind of problem, because this kind of problem will only be magnified over her years. You have to take care of it. It's well over $10,000. Judgment for the plaintiff in the amount of $10,000. Thank you. We're finished.
This court is adjourned.
Guys, assalamu alaikum. Welcome to my channel. আবারও আপনাকে স্বাগতম জানাচ্ছি আমার নতুন আরও একটি ভিডিওতে। আশা করি ততক্ষণ আপনারা সুস্থ রয়েছেন, ভালো রয়েছেন। আর আপনার সঙ্গে কথা বলতে না পারলেই যেমন দিনটায় অচেতন হয়ে যায়, অবহেলিত হয়ে যায়, কেমন জানি লেগে যায়। সো আমরা চেষ্টা করছি একটু আপনাদের সঙ্গে কথা বলার। সো কথা বলতে যদি ভালো লাগে আরও একটু কথা বলবো, আর যদি না লাগে চাইলে এখানেই কেটে দিতে পারবো। কিন্তু আমাদের ভিডিওর একটা রুলস রয়েছে, আমাদের কিছু টপিক রয়েছে, যে টপিক নিয়ে আমাদেরকে পুরোটা সময় ধরে আপনাদের সঙ্গে কথা বলতে হবে। আর আপনাদেরকে অবশ্যই সঙ্গে থাকতে হবে, কারণ আপনারা যদি সঙ্গে না থাকেন আমরা আসলে কাকে নিয়ে কথা বলবো, কি কথা বলবো, কে শুনবে আপনি বলেন। সো এখানে দেখতে পাচ্ছি কিছু শব্দ আছে। আমরা পড়েছিলাম তরঙ্গর যে প্রথম সূচিপত্র থাকে, এই সূচিপত্রটি এখন চেষ্টা করছি পরে যে বিস্তারিত যেই কথাগুলো সেগুলো পড়ার। এর মাঝেই যে পার্টগুলো আসলে ইম্পর্টেন্ট সেই পার্টগুলো আসলে পড়ার চেষ্টা করছি। সো আপনারা অবশ্যই সঙ্গে থাকবেন। আমি একটু পড়ে নিই, আপনি শুনতে থাকুন বা দেখতে থাকুন। আসলে আমার মনে হচ্ছে যে আমরা যেই বিষয়বস্তুগুলো রয়েছে এগুলো যে পড়বো, এগুলো আসলে এখন না পড়ে আমাদের বিষয়বস্তুগুলো পড়া দরকার। আমি আসলে এখানে টপিক পড়ে তো লাভ নেই, আমাদেরকে বিস্তারিত জানতে হবে, কারণ আমাদেরকে টাইম পাস করতে হবে, টাইম মেনটেন করতে হবে, আর অনেক কিছুই রয়েছে যেগুলো আমাদের আগে দরকার। আচ্ছা, এখানে দেখতে পাচ্ছি তরঙ্গের উৎপত্তি। আচ্ছা, পুকুরে, লেকে বা খালি স্থির পানি যদি একটি ঢিল ফেলা হয়, তাহলে ঢিল যেখানে পানিতে প্রবেশ করে সেখানে একটি আলোড়ন সৃষ্টি হয়। আপনি বুঝতে পারছেন, এই যে ঢেউ, এই কথা বলা হয়েছে।